Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations so that, setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, at this time, I would just like to advise of the circular that was sent to you on Wednesday from the Clerk of the House, indicating that Ms. Keeper Jacob Motley has transitioned to another organization, and I wish for you to join me in thanking her for her service to the Senate of the Republic of Trinidad and Tobago. I'm also to advise that our new acting clerk of the Senate is Ms. Chantal LaRoche, who's here with us. And I also wish to welcome her to the Senate of the Republic of Trinidad and Tobago. Honorable Senators, I have granted leave of absence to Senator the Honorable Dr. Amory Brown, Senator the Honorable Rohan Sinanan, and Senator Wade Mark, all of whom are out of the country, and to Senator Hazel Thompson-Aye, who is ill. Honorable Senators, I have received the following correspondence from Her Excellency the President Christine Carla Kangaloo, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Christine Carla Kangaloo, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces. To Mr. Ndali Young, whereas Senator the Honorable Dr. Amory Brown is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)A of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Acting Prime Minister, do hereby appoint you, Ndali Young, to be a member of the Senate temporarily with effect from the 17th of May 2024 and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Dr. Amory Brown. To Mr. Michael Seals, whereas Senator the Honorable Rohan Sinanan is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)A and Section 44(4)A of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Acting Prime Minister, do hereby appoint you, Michael Seals, to be a member of the Senate temporarily with effect from the 17th of May 2024 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Rohan Sinanan. To Mr. Francis Lewis, whereas Senator Hazel Thompson-Aye is incapable of performing her duties as a senator by reason of illness, now therefore I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)B and Section 44(4)C of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Francis Lewis, to be a member of the Senate temporarily with effect from the 17th of May 2024 and continuing during the absence of Senator Hazel Thompson-Aye by reason of illness. given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, the 17th day of May, 2024. Honorable Senators, senators are required to take the oath.
I, Randall Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago, upon which I am about to enter.
I, Michael Seals, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, I will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Francis Lewis, being appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, the Administration of Justice, Indictable Proceedings, Amendment Bill 2024, in the name of the Attorney General.
Attorney General.
Thank you very much, Mr. President. In accordance with Standing Order 62(1)B, I beg to move that the next stage of the bill be taken later in the proceedings.
Honourable Senators, the question is that the next stage of the bill be taken later in the proceedings. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The next stage of the bill will be taken later in the proceedings.
Papers.
Acting Leader of Government Business.
Thank you very much. Mr. President, I have the honour to lay on the table the following papers as listed on the order paper in the names of the Minister of Works and Transport, the Minister of Finance, the Minister of National Security, the Minister of Labour, the Minister of Education, and in my name. The Motor Vehicles and Road Traffic Windscreen and Window Tint Amendment Regulations 2024. The Motor Vehicles and Road Traffic Amendment to the 9th Schedule Order 2024. The Trinidad and Tobago Revenue Authority Extension of Period Number 3 Order 2024. the annual report of the Trinidad and Tobago Securities and Exchange Commission for the financial year ended September 30th, 2023, the annual administrative reports for the Trinidad and Tobago Tourism Business Development Limited for the years 2020 and 2021, the ministerial response of the Ministry of National Security to the second report of the Joint Select Committee on National Security on an examination into the factors that contribute to the prevalence of illegal firearms and gun violence in Trinidad and Tobago, the ministerial response of the Ministry of Labour to the sixth report of the Joint Select Committee on Human Rights, Equality and Diversity on a follow-up inquiry into the implementation of the recommendations of the 18th report, 11th Parliament, on an inquiry into the treatment of migrants with specific focus on the rights to education, employment and protection from sexual exploitation, and the ministerial response of the Ministry of Education to the sixth report of the Joint Select Committee on Human Rights, Equality and Diversity on a follow-up inquiry into the implementation of the recommendations of the 18th report, 11th Parliament, on an inquiry into the treatment of migrants with specific focus on the rights to education, employment and protection from sexual exploitation.
Reports from committees.
Senator Jolene John.
Mr. President, I have the honor to present the following reports as listed on the order paper in my name. The 14th report of the Public Accounts Committee on an examination of the report of Auditor General on the public accounts of the Republic of Trinidad and Tobago for the financial year 2022. The 15th report of the Public Accounts Committee on an examination of the reports of the Auditor General on the financial statements of the Police Complaints Authority for the fiscal years 2015 to 2021, and the 16th report of the Public Accounts Committee on an examination of the reports of the Auditor General on the financial statements of the Airport Authority of Trinidad and Tobago for the financial years ended December 31st, 2013 to 2019, and follow up on the implementation of the recommendations contained in the 18th report of the Public Accounts Committee from the 11th Parliament. Thank you.
Questions on notice? Questions for oral answer?
Acting Leader of Government Business.
Thank you very much, Mr. President. Mr. President, there are 3 questions for oral answer, and as is usual, government is prepared to answer all 3. There is 1 question for written answer, question number 64, and it is ready and available for circulation.
Senator Roberts.
Thank you, Mr. President. Through you, question number 102 to the Honorable Minister of Social Development and Family Services.
Minister of Social Development and Family Services.
Thank you, Mr. President. The Ministry of Social Development and Family Services received a report of a fire from the Couva Tabakit Talparo Regional Corporation Disaster Management Unit. This fire occurred on Sunday, the 14th of April, and the Ministry of Social Development staff paid a site visit the next day, Monday, the 15th of April, 2024, and conducted assessments of 3 families. As follows. Geeta Umadat Rajkumar household, which comprised of 2 persons, Meena Umadat household comprised of 2 members, and Rory Ramprasad comprised of 1 person. As a consequence, the ministry provided the following assistance. Each family was provided immediately with temporary food support at the value of $550. Counseling support through our National Family Services Division was offered. Letters were issued to the head of household of each family to obtain quotations for the receipt of household items, clothing, and school supplies as required. Rental assistance grant was also offered to the family, but no family accepted. They declined this grant. Documents outlining the requirements for the minor house repair assistance, sanitary plumbing assistance, and house wiring assistance grants were also offered to the affected families. An update is that some clients have submitted their quotations for the general assistance grant already to the ministry, and it is currently being processed.
Senator Roberts.
Thank you, Honorable Minister, and through you, Mr. President, is there a policy for dealing with fire victims throughout the country, and if so, what is that policy? And and part B of that question is, what is the time? It appears that the assessment was done immediately the next day. What is the normal lag time to get help to the victims of fire?
So, Senator, you're asking two questions. The first question,
All right.
Senator, Minister, first question.
But I know you're bright now.
Actually, I will answer the second one first. Actually, it is dependent on when...
Senator, he asked two questions. And the way supplementals work is you have a certain number. So you have to answer the first one he asked. If he wishes to repeat the second one, he can do that on the second supplemental.
Could you give us the first question, please?
Is there a policy for dealing with fire victims across the country from your ministry?
Yes, definitely there is a policy. Of course, once there is a fire, we liaise with the Trinidad and Tobago Fire Service and also the regional corporations. The regional corporations are really the first responders, and they are the one who liaise with us. And then we liaise with the fire victims. And then we offer all the services that is available to them.
Thank you, Mr. President. And what is the normal time span taken to assess and deliver services or help, financial aid, food, and so on, to these victims?
Well, with regards to that, it is dependent on the information when we receive the information from the family. Because the family, we would assess, we would offer the services, but sometimes the family would have problems getting the fire report because they must get the fire report. So there are times there's a delay in the fire report from the family and also bringing in the invoices for the required goods.
Senator Roberts.
Thank you, Mr. President. Question number 103 to the Honorable Minister of Energy and Energy Industries.
Minister of Energy.
Thank you, Mr. President. Mr. President, the April 2024 reports in respect of the sanctions imposed by the United States on Venezuela's oil and gas sector relate to General License 44. The amendment to the OFAC General License 44, which is now known as License 44A, does not affect the specific amended OFAC license that was issued to the government of Trinidad and Tobago on the 17th of October 2023. I repeat, it does not affect our position. That license, the amended license of October 17, 2023, authorized the government of Trinidad and Tobago, the National Gas Company of Trinidad and Tobago Limited, NGC, Shell PLC, and their affiliates to conduct business with the government of Venezuela and PDVSA with respect to the Dragon gas field in Venezuela. The specific amended OFAC license issued to Trinidad and Tobago on the 17th of October 2023 is valid until the 31st of October 2025 and permits Shell, NGC, and contractors to continue the works being undertaken to explore, produce, and export natural gas from the Venezuelan Dragon field to Trinidad and Tobago. Additionally, I remind the population and the public, through you, Mr. President, that Trinidad and Tobago secured a 30-year exploration and production license from the government of Venezuela on the 21st of December 2023, a 30-year E&P license for the Dragon gas field. And the work to explore, produce, and export the natural gas from this field to Trinidad and Tobago is, in fact, continuing.
Thank you, Honorable Minister. Through you, Mr. President, from the information just garnered from the Honorable Minister, based that the OFAC amended license given or awarded to Trinidad and Tobago on 17th October, that it goes until the 31st of October 2025, and that Trinidad and Tobago has been given a 30-year agreement with the government of Venezuela to monetize and to explore the Dragon Field. Has the government of Trinidad and Tobago been able to sign a contract, a joint venture agreement, or a partnership agreement with a multinational corporation moving ahead? Has that been achieved?
Minister.
The answer is yes. Trinidad and Tobago, through the National Gas Company, has signed a joint venture agreement with Shell for the exploitation of the gas on the Dragon gas field, and the exploitation of that gas and the export of that gas to Trinidad and Tobago. Such an agreement has been signed with Shell.
Senator Roberts.
Thank you, Mr. President. In this agreement, does the geopolitics, as stated by the Honorable Prime Minister, affect this agreement in any way, especially with the agreement with Shell, the multinational corporation who will be charged with the bulk of the infrastructural development to monetize this Dragon field? Is that affected in any way? Minister. Or can it be affected in any way?
Mr. President, geopolitics affects everything. So geopolitics continues to affect Trinidad and Tobago and other areas of the world. It means tangible and intangible. This deal was consummated with a 30-year license, which has never happened, exploration and production license, to the government of Trinidad and Tobago, NGC and Shell from Venezuela. The OFAC license, no OFAC license has been granted for Venezuela in as long a term as 2 years as Trinidad and Tobago have gotten. Chevron have a 3-month to 6-month license that continues to roll over and over. So the answer is geopolitics affects it. Does it affect Shell and the work we are doing? The answer is no. We are proceeding full speed ahead. 2 weeks ago, I met with the second rung under the CEO, the global CEO of Shell, right here in Trinidad and Tobago, Zoe, and we are proceeding full speed ahead. Hopefully in the not too distant future, you will see a survey ship going to the Dragon gas field with our people on it to begin the work on the Dragon gas field. Right now, the engineering work is taking place, the designs are taking place, and all of the work that is to be expected is taking place between Shell, NGC, Venezuela, and Trinidad and Tobago.
Senator Roberts.
Thank you, Mr. President. Seeing that the Honorable Minister said geopolitics affects everything and could affect this deal, does the Honorable Minister have confidence that come October 31st, 2025, that this OFAC amended license will be renewed? And if there is a risk that it cannot be renewed, how can the government tell the population that we have to pay $7 million per year for something that may not happen due to geopolitics?
Minister.
Thank you very much. The sum of money that the Senator has referenced is a normal payment with the signing of any exploration and production license. In fact, just this morning in discussions with the Ministry of Finance and looking at it, we have a number of companies in Trinidad and Tobago that are paying us on an annual basis for scholarships for sums way above $1 million US, and they have not even begun to explore the fields and the blocks that we have granted licenses to them for. So to suggest that the sum of $1 million US being paid as part of the exploration and production license with Venezuela is something unusual, it absolutely is not. The revenue that we stand to benefit from and derive from this deal will be in the billions of US dollars. We will continue to progress. No one can predict what will happen with respect to geopolitics or anything in life. At this stage, I can't predict who will be the chairman or the deputy chairman of the UNC come the end of next month. So that shows we will continue to do all of the work in a competent and confident manner that we have continued to do so, and we will continue to do what is best for the people of Trinidad and Tobago.
Thank you, Mr. President. A brilliant waffle by the minister who did not answer the question. The question that was asked and it was not answered was, does the government feel confident that $1 million without the surety or the certainty that any revenue will be forthcoming to this country was a correct, responsible decision?
Minister.
The answer is absolutely yes. That sum was negotiated downwards. And I take the opportunity to remind the population that that $1 million spent is a revenue-generating expenditure as compared to the $400+ million spent on live sport that produced nothing but criminality for Trinidad and Tobago to deal with.
Next question on the order paper.
I have nothing else. Small mind, small brain, small pin. Yes, next question for the Honourable.
Have a seat.
I'm not.
No, members. Both sides, both sides. Senator Roberts, next question on the order paper.
Thank you, Mr. President. I'll just take a small pin there. Question number 104.
Have a seat. No. When I call for the next question on the order paper, just state the question. Leave all of the extra stuff out.
Thank you, Mr. President. Question number 104 to the Honourable Minister of Public Utilities.
Minister of Public Utilities.
Thank you very much, Mr. President. Mr. President, the Water and Sewerage Authority has taken action to strengthen enforcement and ensure compliance with the provisions of the Water and Sewerage Authority Act and has implemented a proactive and determined approach to eradicate water trucking scams in Trinidad and Tobago. With respect to the current small fines for illegal extraction, distribution, and sale of WASA's water, there is no doubt that this fine is outdated and obsolete. And with the fluctuation of time, it no longer serves as a deterrent to these serious acts or wrongdoing. The Water and Sewerage Authority is currently undertaking, Mr. President, a comprehensive review of the Act that governs its operation, including fines for various illegal practices that endanger or undermine the ability of the authority to provide services to the citizens of Trinidad and Tobago. It is expected that this legislative review can be completed and appropriate amendments to the Act presented to Parliament by the end of 2024.
Thank you, Honourable Minister. Through you, Mr. President, how many, if any, perpetrators of this heinous fraud have been caught or charged, even though the fine may be minuscule? How many people have been caught doing this illegal charging for trucking of water?
So that question doesn't arise out of the original question, Senator Roberts. Next question.
Good. Thank you, Honourable President. What communication strategy has been implemented by the ministry and by WASA to alert citizens of this ongoing fraudulent practice?
Minister.
Mr. President, recently the Water and Sewerage Authority, the Board of Commissioners and the management, they have expanded the resources and the operations of the call center to allow citizens access to WASA's operation to request water trucking services. The call center operation has been now a 24/7 operation, so therefore citizens requesting truck-borne services now have access to WASA and to make the appropriate request for free truck-borne supply of water.
Senator Roberts.
Thank you, Honourable Minister. Honourable Minister, the lead-in time, and I have personal experience with it, to get the truck-borne water to a household is approximately 2 weeks, 6 months ago. Has that time been reduced? Has the WASA or the ministry increased the number of available trucks and so on to serve the country and the population?
Minister.
Mr. President, I'm not aware that where the Honourable Senator has gotten his information. So therefore, I will not verify that information. But however, I can assure the citizens of Trinidad and Tobago that recently WASA has expanded its fleet of water trucking operators. We have contracted several more water truck operators to be deployed strategically in areas that are unserved and underserved. So in addition to the expansion of the call center operation to a 24/7 operation, additional truckers, perhaps over 70 water truckers and tankers, are now available to provide to citizens requesting and desiring a supply of water in the various communities across Trinidad and Tobago.
Senator Roberts, final question.
President, from the minister's answer, can one glean that due to the improvements being made in the truck-borne supply now, that previously the country was underserved by this service for the last 8 years?
I won't allow that question, Senator Roberts. That's it. Yes.
Public business, government business, bill second reading.
Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Mr. President, I am very privileged and pleased to appear before you and this honorable House today to speak to the Administration of Justice Indictable Proceedings Amendment Bill 2024, which was passed with an amendment in the other place on Monday, the 13th of May, 2024. Mr. President, we have long spoken of preliminary inquiries, which have long been recognized as a bottleneck in our justice system. In March 2023, prior to the proclamation of the Administration of Justice Indictable Proceedings Act 2011, also known as AJIPA, nearly 38,000 indictable matters languished in our district courts. In point of fact, Mr. President, even as we stand here today, there are matters still at the stage of preliminary inquiry in our courts which are in existence for in excess of 13 years and have not yet reached the stage of indictment. Mr. President, in appreciating the amendment which is before the House today to further the objective of AJIPA, we have to appreciate that the relief which AJIPA is intended to bring and is bringing represents cases which not only affect the individual accused, but also affect the victims, their families, and the communities who are all waiting for closure and justice in outstanding matters. This government, Mr. President, took the decisive step to finally abolish the antiquated pretrial procedure of preliminary inquiries that plagued our justice system. For the first time in our history, a novel, efficient, and electronic approach to pretrial proceedings has been established. The abolition of preliminary inquiries, Mr. President, is one of the major reform initiatives undertaken by this government that works in tandem with several other reforms and demonstrates our commitment to achieving swift and fair justice for all through a comprehensive overhaul of the criminal justice system. To name a few, Mr. President, we have seen the establishment of specialized court divisions, the introduction of judge-alone trials, the decriminalization of certain road traffic offenses, new plea bargaining legislation, the establishment of a public defender system, and significant resources consistently applied to the justice sector to improve its plant, its machinery, and its processes. The long-awaited abolition of preliminary inquiries through a JIPA complements these significant reforms. What is also of enormous importance, Mr. President, in the 10 years since we have been moving through the enactment of a JIPA and finally bringing it home, is the continued involvement of all parties in the process. The government has actively engaged key stakeholders for the past 12 years in order to continue to gather feedback and to refine our approach to the abolition of preliminary inquiries and the implementation of a more efficient pretrial mechanism. In June last year, 2023, I stood before this Honourable House to introduce the Administration of Justice Indictable Proceedings Amendment Act 2023, Act number 12 of 2023, which provided, Mr. President, for, among other things, the enforcement of electronic filing, which reduces the archaic paper-based systems, the requirement for early filing of the indictment, as this has been identified as a source of delay in plea agreements as well, stricter timelines for compliance by all parties to the proceedings, the elimination of the requirement of cross-examination and additional oral evidence, steering pretrial indictable matters out of the district courts, formerly called magistrates' courts, placing pretrial indictable matters before the masters of the High Court and the Criminal Division, thereby allowing for earlier identification of matters to be tried summarily, ensuring case readiness through the introduction of timelines and scheduling orders, and effectively allowing for the sufficiency of the evidence to be determined through an assessment of documentary evidence as opposed to the laborious eliciting of oral evidence and the many years of cross-examination that has plagued this system in the pretrial preliminary inquiry process. Mr. President, in talking about the consultation which this government has been engaging in and continues to engage in, our stakeholders have included, but are not limited to, the Judiciary of Trinidad and Tobago, the Trinidad and Tobago Police Service, the Office of the Director of Public Prosecutions, the Public Defender's Department of the Legal Aid and Advisory System Authority, the Trinidad and Tobago Prison Service, the Law Association of Trinidad and Tobago, among others. Mr. President, in that process of consultation, as recently as December 2023, the Judiciary of Trinidad and Tobago, in collaboration with the Office of the Attorney General and Ministry of Legal Affairs, embarked on a sensitization program for stakeholders in the criminal justice system on a JIPA and the systems and processes contained therein. During those sessions, the judiciary demonstrated the new electronic filing systems for initiating indictable matters before the High Court through the novel web portals using case lines and case center software for all evidential uploads, evidential management, and case presentations. I am pleased also, Mr. President, to inform this House that the groundbreaking impact of the proclamation of a JIPA has been coupled with the newly introduced Criminal Procedure Rules of 2023, which has continued with a JIPA to move forward the swift administration of justice. Very significantly, Mr. President, and we spend a lot of time in this place and in the other place talking about the independence of the different arms of the state, the judiciary, the executive, and the legislature. And very significantly, as we move to look at the bill that we are here to debate today, we have had a very recent example of a concept of our separation of powers that is least spoken to, the interoperability of the separate arms of the state, the legislature, the cabinet, and the judiciary. What do I mean by that? We have brought a JIPA, the cabinet, the executive, to this parliament. The parliament, in its two houses, have given the opportunity to parliamentarians to debate and to refine a JIPA and to pass it into law. And then the judiciary, in the interoperability of which I speak, in progressing and advancing our society, takes the baton from there and begins to implement. So as recently as January of this year, Mr. President, in the case of the state against Sheldon Dudnath, which was published by the judiciary in a media release on the 1st of May, we learned of a decision which is being presided over by Madam Justice Lisa Ramsume-Hines. That case was filed, and the dates are significant. When we think back to the 13-year-old delay in preliminary inquiries, which has been eliminated by AJIPA, the case was filed on January 11th, 2024, with alleged offenses including kidnapping and larceny of a motor vehicle. The sufficiency hearing, the process by which all of the evidence to take the case to the stage of an indictable commitment at the assizes, which is now in documented form, no cross-examination, the sufficiency hearing was concluded by the judge on April 16, 2024, with the accused being committed to stand trial before the San Fernando assizes. 4 months, Mr. President, in place of the perennial wait of 6 to 8 years, sometimes amounting to 13 years, to move a case from the summary trial before the magistrate to the indictment before the assizes. So we have the remarkable situation in 2024 in which a case 4 months after the accused was charged, the pre-trial proceedings commenced, the initial and sufficiency hearings were completed, the master committed the accused to stand trial, the accused appeared before a high court judge for trial, and the presiding judge now indicates that she anticipates that the case will be completed before the end of July, a mere 6 months after the filing of the indictment. Let me repeat that, Mr. President. The judge has indicated that the case is expected to be completed a mere 6 months after the filing, after the charge of the accused before the first instance court. That, Mr. President, is what AJIPA has brought to this country through the efforts of this government. Coupled with AJIPA has been introduced, as I have said earlier, the Criminal Procedure Rules 2023. And among the things that the Criminal Procedure Rules has brought into effect is the case progression officer. Cases are now being managed by the judges through the case progression officer. So when we read the order of the court, the judge who has moved the case already through 4 months and is expecting to manage the case to completion by by July of this year, we see that one of the orders that the judge has pronounced on is to say that no deadlines and no timetables fixed by her order may be altered by the agreement of the prosecuting and defense counsel without her permission. So you're not allowed as lawyers managing the case to take the case away from the charge and trial conduct of the trial judge. If you want any extensions, you have to come back to the judge and justify it. That is how we are going to move the system forward. And that is how, under the new AJIPA process and the criminal procedure rules, the court is now driving the process to ensure that persons get a fair trial in an expedited period of time. What the criminal procedure rules, Mr. President, 2023, which are in tandem with AJIPA, highlight is that there is now a responsibility on attorneys to advance the case without using court hearings to do things, and parties can manage themselves, allowing precious court resources not to be wasted. Madam Justice Ramsume-Hines expressed the objective of resolving non-capital indictable matters within a year and capital indictments within 2 years. This is the progress that we are speaking to as we look at the bill that is before us today. And may I indicate, Mr. President, in looking, before I turn to the clauses of the bill that we are looking at today, that we are here today to move an amendment, 2 short amendments to 1 clause of AJIPA, Section 21, because in the continuing stakeholder consultation, that all citizens and entities of this country are committed to, the Office of the Attorney General and Ministry of Legal Affairs received correspondence from attorneys representing the Board of Inland Revenue, attorneys representing the Director of Public Prosecutions, the Public Defender's Department, and the Police Complaints Authority. And it is they who, as they see the process of a JIPA working its way through the system, have brought to our attention some of the teething problems that are being experienced by what is new legislation, and have asked us to come back to this House for the few amendments that we wish to introduce today. So if I can now turn to the substantive provisions of the bill which is presently before the House, Mr. President. Clause 1 provides, as we'd expect for the short title, Administration of Justice Indictable Proceedings Amendment Act 2024. Clause 2 deals with interpretation. It clarifies that throughout the bill, the Act refers to the Administration of Justice Indictable Proceedings Act and ensures consistency and understanding of terminology within the legislation. It provides for clear titles and nomenclature throughout. Clause 3 constitutes a substantive provision of this bill. Mr. President, the current Section 21 of the bill of a JIPA was circulated, as I've said, for wide stakeholder comment prior to proclamation. And what we are introducing at Clause 21(1)(a) is to provide that witness statements must be signed by original statement recorded by the police officer or by the witness. The first proposed amendment to this section involves the insertion of a new subsection 9, which would incorporate the definition of police officer as outlined in the Proceeds of Crime Act, Mr. President, which is borrowed. So we are borrowing from the Proceeds of Crime Act an enlarged definition of police officer to ensure that the prosecution can commence with parties who play a role in the initiation of proceedings who are not exclusively police officers. So subsection 9, clause 3b, is to insert after subsection 8 the new subsection 9. For purposes of this section, police officer means an officer of the Trinidad and Tobago Police Service and includes an officer of the Customs and Excise Division, an officer of the Board of Inland Revenue, or any other officer of an agency of the state lawfully vested with investigative powers similar to those exercisable by a police officer appointed under the Police Service Act. That's the first substantive and the main amendment that we seek to introduce by Clause 3 in the bill before this August House. Additionally, Mr. President, we wish to amend, and this is indicated at Clause 3, Section 21, in subsection 2, in paragraph A, by inserting after the words police officer or the word given, so that this enables acceptance of statements provided by witnesses directly or recorded by authorized persons other than police officers within the strict definition of police officers. Mr. President, as I said before, those amendments have been brought to this House, and I pay tribute to them by the very worthwhile contributing enhancement of the process from correspondence from the Board of Inland Revenue, the public defenders, the Director of Public Prosecutions, and the Police Complaints Authority. It is important, Mr. President, and I signal this to this House, it is important to appreciate that we continue to engage in our stakeholder consultation so that we have continued to we've issued correspondence, my office, on the 26th of March 2024 to key stakeholders requesting feedback on other issues facing the implementation of a JIPA since its proclamation. Some stakeholders have responded, and I thank them for their respective submissions. We await feedback from others, and it is very likely that we will be coming back before the other place and this House for some further enhancements of the legislation as we refine it by way of amendment. And if I may just mention one or two other things as I close, Mr. Speaker. That process of stakeholder engagement includes our international partners, so that my office is in collaboration with the United Nations Development Programme through the Peace Justice Project, which aligns with this government's focus on addressing case backlogs, aiming to integrate software, hardware, and capacity interventions to mitigate current and to prevent future challenges in the criminal justice system. This project is intended to deliver improvements to court and case management systems, modernization of procedures, deployment of information and communication technology, training of police, prosecutors, judges, and court staff, and enhanced coordination across the justice sector. Even as I speak, Mr. President, a first batch of equipment has already been delivered through the efforts and the collaboration of UNDP to the Office of the Director of Public Prosecutions and the Trinidad and Tobago Police Service. AJIPA, Mr. President, represents a pivotal milestone in our ongoing quest to improve our administration of justice and to provide for a more effective and efficient judicial system. Just as technology advances at a rapid pace, Mr. President, so too must our approach in delivering justice. We cannot afford to be complacent in the face of mounting caseloads and lengthy delays. The AJIPA is not just a piece of legislation. It is a strategy to modernize our justice system, to deliver swifter and more effective justice. All stakeholders are playing their part, and I applaud them and I thank them. And with that, Mr. President, I beg to move.
Mr. President.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Senator Lutchmedial-Ramdial.
Thank you. Thank you, Mr. President. Mr. President, we are here today to debate some short and what would appear to be very innocuous amendments to the Administration of Justice Indictable Proceedings Act 2011, also known as AJIPA. And Mr. Vice President, I'm happy that the Attorney General has taken some time to go through what I would say, the fruits of AJIPA, which of course, as the Act would reflect, Act number 20 of 2011, came out of a policy of the People's Partnership Administration. So it was a vision that began in 2011, and we are seeing the fruits of that vision here today, bearing out in terms of the rollout of that piece of legislation and the elimination of preliminary inquiries in particular, which, as the Attorney General has said, was seen as a bottleneck in our system. We have now replaced the old system of preliminary inquiries with sufficiency hearings. We have greater use, or we are attempting to have greater use of technology to see if we can expedite those hearings and that we can have a swifter pace of justice for all parties involved, not just accused, but particularly victims and society as a whole, because we all have an interest in ensuring that matters move through the court system very speedily, and that society feels that justice is in fact served when you have criminal activity. As crime continues to increase, I think the cry for justice and speedy justice is something that we will continue to, as public officials, we will continue to hear the public clamoring for more, for swifter justice to be dispensed in relation to these offenses. Mr. President, as the Attorney General has gone through some of the background information to AJIPA, I just want to make a couple of comments in response to, and to contribute and to add to some of what he has said before I get into the specific provisions of the bill. We've looked at, and he has mentioned, the Attorney General has mentioned that this is an ongoing process. And in any case where you have a paradigm shift of this magnitude, you would expect that there would be some teething problems that have to be worked out. And for example, the public would have been privy to what I consider to be an unfortunate display in the public domain of a disagreement with respect to the use of electronic bundles, committal bundles, and getting committals filed and so on. And this highlights for me the necessity to ensure that we have consistency across the board, because for those who don't understand perhaps the different roles and functions of different offices within the judicial system. It is exactly that. It's a system. There are many different entities that all have to be working together, and they all have to be on the same page, and they all have to understand what the other one is doing. And so the case of one of our legal luminaries, who was unfortunately taken way too soon from us, and that matter pending, and the committal bundle or there being some confusion about the transmission of a committal bundle, highlights the need for us to streamline processes. And so I would hope that that unfortunate scenario that played out would lead to some deeper analysis as to what changes need to be made, whether they be legislative or whether they be just simply procedural things that have to be put in place, whether it's a resource problem, or whether simply people just need to start speaking to each other a little more frequently and have someone take the lead in ensuring that we smooth out these processes so that we don't run into these issues very with such, a glaring public display. Because at the end of the day, what really happens when you have all of this is that it will eventually play out in the media, it will go away, but there's a damage that is caused to confidence in the overall system of justice in Trinidad and Tobago. So as we have this major paradigm shift towards what AJIPA has envisioned, we have to ensure that we iron out these creases, because there are some big creases, there's some small ones, but there are some big ones that cause a lot of discomfort amongst members of the public, and so we want to get those things done. It requires equal application of resources, and we've had many joint select committees, we've had many debates in this House, and we've had many public discussions about the DPP's office and their ability to implement some of the changes that the Attorney General spoke about. Because he spoke about the digital movement, which we support and we are in favor of. He has made mention of the criminal procedure rules and what it requires and how it requires parties to now move cases forward, and you are under the supervision of a case management officer. Parties can no longer simply ignore directions and deadlines set by the court. But are these bodies properly equipped? It's one thing to do away with a preliminary inquiry and move straight to an indictment. An indictment, filing of an indictment is not a piece of paper that somebody sends to the DPP to sign and it goes to the court. It is a process. I hated doing indictments when I worked there. It is a real painstaking process. And one of the reasons for this issue with the Dana Sitahal file and the committal bundle is because you actually have to physically go through some of the written documents that are tendered into evidence at the committal proceedings. And it's a painstaking process. And that's why I think the issue of the electronic bundle and so on reared its head. But I leave that for the line ministry to sort out and to work on. But I'm saying that if that department isn't properly resourced, we're going to hit another bottleneck there. Because the DPP, in appearing before parliamentary committees and so on, has highlighted that the staff that he has currently are very inexperienced. And with that very inexperienced staff, we can sit here and fix all of the procedures, and we can be very happy about the procedural aspects and what the law has now fixed in terms of procedure to eliminate PIs and all of that. But we may be creating a bottleneck down the road. For example, the sufficiency hearing has to be conducted by a master. Look at how many of the masters who now sit in the Supreme Court to conduct those sufficiency hearings represent the upper and middle level of what was once the DPP's office. Many of them. The judiciary has put out releases showing who have been elevated to the position of master, and I congratulate all of them, and I'm very happy for all of them, but it has left a void in that department. So without that department getting the resources, we may hit some further bottlenecks down the road. So I make that comment just by way of saying that, look, we have to continuously assess every institution that plays a role in this particular system for AJIPA to really achieve the objective that we wanted to object. Mr. President, I know that some mention has also been made of the sufficiency hearings where we can look at documentary evidence. And that sounds good. And for the purpose of the public who might think to themselves, well, why wasn't this always the case? as much as looking at documentary evidence, including witness statements, can help you arrive at a conclusion as to whether or not a prima facie case is made out, which was really the purpose of the preliminary inquiry. We cannot, for a moment, really overlook the fact that without a preliminary inquiry, without cross-examination, with a simple sufficiency hearing, you may also lose the opportunity to test the veracity of witnesses at the preliminary inquiry. And although that isn't usually something that is done, I have seen cases where it's very important that you root out. Some cases are very heavy document-based. Fraud cases, for example. So you can read all of the documents at a sufficiency hearing, the judge, the master, whoever it is, and you can come to the conclusion that yes, a prima facie case is made out and this should move to an indictment. That's fine. But there are some cases, and we still have many criminal cases in this country, that hinge on testimony of one or two key witnesses. And I wouldn't say it's a downside, but it is something that we would lose if not carefully managed at a sufficiency hearing stage to test the veracity of witnesses. You know, I'll never forget, I did a case once where the witness statement was tendered into evidence. Although it's a preliminary inquiry, we use the opportunity to tender the witness statement. And that witness made a statement about himself and the victim, and he said that we had a platonic relationship. And all the defense attorney had to get up and ask the man, do you know the meaning of the word platonic? Could you tell us? And he couldn't answer because the witness had no clue what platonic meant. Because he didn't write that witness statement. The police wrote it for him and gave it to him to sign. And my whole case fell down because that was the only key witness that had any evidence against that accused. And at the point of a preliminary inquiry, that case fell and was out of the system. So we have to ensure that in all of these procedures, we do not prioritize, having an expeditious hearing for having a quality hearing. Because in a normal situation where a magistrate or, a master conducting a sufficiency hearing reads a statement like that, yeah, he might get to court in 6 months, but the case may flop at the stage of the High Court. So it's a resource issue. It's looking at how best we manage cases, and so we go down the road. Now, that's just some preliminary and background information because we've been discussing AJIPA as a whole and how it has been functioning. With respect to the clauses of the bill, very short, but they are very important. And I'll get to the first one. In the amendment to Section 21, which is in Clause 3A, we are adding the word given. And this is important because, of course, if you don't have proper procedures, witness statements can be challenged. And one of the things that we see now happening a lot in the criminal justice system, persons who are not necessarily under investigation or who are not suspects in a matter tend to be asked to give statements, and they prefer, rather than coming in to give an interview to the police, which is very painstaking and takes very long and scheduling issues and all of that, they will ask the police to send them questions, and they prepare statements and they give to the police. So this clause really allows those given statements to now be used and to form part of the proceedings. And that's not really objectionable per se. It only ties into the other section where we have to ensure police understand, I think, the manner in which these statements have to be treated, because they have to be examined very carefully for hearsay. They have to be examined very carefully for information that might be, need to be the subject of follow-up interviews and so on, because that is the usual process that the police will adopt. And we have to ensure that all persons conducting investigations know and understand that. Just today, before we came here, we were in a JSC where we were discussing the production of witness statements by financial institutions. And when you're dealing with fraud and white-collar crime, for example, we depend very heavily on witness statements coming out from the banks and the financial institutions to, for example, exhibit certain information. Would persons who are giving statements be adequately familiar with the rules of evidence and so on? So it requires that we cannot simply accept and give statements, but that these statements must be, and the investigators have to be sure. And we cannot allow given statements to make its way into a trial without being subject subjected to the same level of scrutiny as statements that will be recorded by trained investigators. So it's not objectionable, and again, this is a very procedural bill, and it deals with the procedure. The given statements should be able to be put into evidence, whether it is at a sufficiency hearing or even later on a trial. But we want to make sure that that is done. Otherwise, objection, if the word isn't there, objection could be taken, I suppose, by the other side, that it wasn't a statement taken by the police, but rather given by somebody else. The other section, section 21, is amended, and this is clause 3B. Replaces previous definition, inserts a definition, and it expands what police officer is to mean. And this definition is now lifted out of proceeds of crime because we want to have consistency, recognizing, of course, that people outside of the TTPS can, in fact, conduct investigations. And again, that is very important when it comes to fraud, white-collar crime, tax evasion, customs offenses, and so on. We're going to have persons in those different agencies conducting investigations. I want to make a very short point here because it comes up from time to time, especially when people from the other place visit, and we talk about the Trinidad and Tobago Revenue Authority. And the opposition is always heavily criticized that we don't support the TTRA, and because of that, we had to, or it was necessary for the government to preserve the enforcement divisions of those two entities, which will now become the TTRA. This is a perfect illustration of why. Because in all procedures and processes and proceedings before the court, persons who belong to these bodies, now known as Customs and Board of Inland Revenue, which enjoys a certain insulation as public bodies under service commissions without, we would hope, the possibility of interference and so on, will one day become vested with the exact same powers of police officers in the conduct of court proceedings. And they will fall under and had it not been for the opposition standing in the gap and insisting that we will not support the movement of those positions into a body that does not enjoy that insulation, those investigative positions would have been coming under a board appointed by a minister. And that is exactly this bill and this amendment here today, and the vesting of the same powers of police officers to conduct proceedings, to take statements. Could you imagine that had we agreed to and allowed the TTRA bill to become law in the form that the government originally envisioned, and we had supported it, the consequence of that today, and that is what vision and foresight is about, we could see consequences. The consequence of this amendment today would be that persons who could have been hired by a director who's appointed by a board, which is appointed by a minister, would have the same powers of police to interrogate you, to receive a statement from you, to bring you in and record a statement from you, and then tender it into evidence. And those persons, had they fell under that body, would not enjoy the same protections as police officers who come under a commissioner of police, which, should be appointed by an independent police service commission. And that is where consequences flow from one thing to the next. So I want to make that point just because this came up here today, and many people see legislation in isolation. And they say, well, this is a simple thing. We have it in proceeds of crime, so we want it to. I know we have it in proceeds of crime. I know we're going to have it here too. And that's why I know I don't want any investigative officer from Customs or BIR to be sitting in a TTRA hired and controlled by a board appointed by a minister. So I make that point today to bring some justification and to dispel some of the criticism that is often levied against the opposition for not supporting the inclusion of investigative officers of the Board of Inland Revenue and the Customs and Excise Division under the TTRA. It is for this exact reason that we see here today. I have no problem with independent officers who have been vested with powers such as this under POCA and other pieces of law for a long time, continuing to do their work. It is very important work. We are seeing a proliferation of white-collar crime. We want to see more investigations coming out of the Board of Inland Revenue and Customs and Excise Division. And from a procedural standpoint, we want them to be included in this. So we will not object to the clause today at all, because we understand the importance of the role and function that they play. And it is for that reason that we understand the importance of their independence, and we have fought so strongly and advocated so strongly for it. So with those few words, Mr. President, I thank you.
Senator Maharaj.
Thank you very much. My comments on this bill would be very short, because I recognize the relief of the Attorney General in moving this process forward. From the public's perspective, the entire administration of justice is a totally logjam sector. And every single day we are treated to the stories like the one the previous speaker mentioned, something that just makes no sense, a bundle of documents or that's sent electronically when you actually need the physical. And for that reason, not only such a high-profile person as the victim in that case has suffered, but many, many more people are stuck in the system with no way out. The cost of that to the country is unconscionable, and the cost in terms of human suffering is even worse. So any indication of progress towards making the system a little more efficient is to be congratulated. In this case, the Attorney General has identified one particular case that will move through the system in a rapid pace of 6 months. But that's one. And I want to know whether that is an exception or that is going to be what can be expected. And to know whether that is the case, what should be happening is that we've introduced something, we should be tracking the data to see whether we are seeing a percentage movement. We are seeing a reduction in time. We are seeing something that tells us that this is real and not just an isolated case. And I understand that the judge is doing her best, but that in not every case will she be able to say, this is why she's retaining the discretion. Is that a policy that judges are going to be doing that? They're taking a position that I'm not going to allow lawyers to go behind, the back and go in the back room, make their deals, prolong the cases, charge their clients even more and more and more. But judges are going to do that where it's reasonable to do it. Can you say anything more about that? I think we have a system that is so chronically dysfunctional, because what we have are these silos in which the entire administration, we talk about the administration of justice, but that's a massive sector dealing with something as important as justice and life and death matters. And there are so many elements that are part of that. And what we need is an integrated solution, but it's difficult to come up with integrated solutions, as the evidence shows that we've had so many studies and so many attempts and so many inquiries into the state of the administration of justice, and yet have not been able to make the kind of progress that you should make. In this case, it's been 12 years. And any reasonable mind in the public is bound to ask, well, why did something like this take 12 years? In terms of the bill itself, I heard what the previous speaker talked about, the definition of police officer. And she linked it to the opposition's position on the TTRA. I wonder whether that is a clean categorization of police officer. If the Police Service Act defines police officer as a person who is appointed to perform the duties of an office in the police service, if the Act defines that, might it not be better to say a police officer or any authorized person and define what other authorized persons may be? I'm a little uncomfortable with one piece of legislation defining the police officer in that way as somebody in the office in the police service, and extending in another piece of legislation the definition to include many more people. But I am not a lawyer, so I leave that to the lawyers too. I just put it on the table for their consideration. In terms of the, there's an amendment to determine between or and, which is the 21(1)(c) to replace or with and in order to ensure that witness statements, they have the choice of these conditions, or the statement is signed by the witness in the presence of a police officer and dated, or is also sworn before specified officials, or and is sworn before specified officials. I understand from listening to the Attorney General that he's awaiting some input from people, that stakeholders. He's consulted on that. But frankly, I would go with and. I do not think we should just have a police officer dating something alone with this witness. I think we need another set of people as a check and balance in this. So with that, I will rest. Thanks.
Acting Leader of Government Business.
Thank you very much, Mr. Vice President. I too don't intend to be long, but Mr. President, sorry. Yeah, I too don't intend to be long, but let me just touch on some of the matters that Senator Lutchmedial-Ramdial had mentioned. Of course, we expect Senator Lutchmedial-Ramdial to speak about the resource argument. I mean, Senator has made that argument time and time again. But the senator went a little further to agree with the Attorney General to say that there should be a level of interoperability. I think you said that these branches should speak a little more, and they should discuss ways to improve and the methods and the means to ensure that there are improvements to the criminal justice system. Mr. President, I don't need to say much more on that, especially with what's going on in the national community today. But I certainly agree wholeheartedly with Senator Lutchmedial-Ramdial and with the AG that there should be some interbranch communication, some interbranch cooperation with a view to improving the criminal justice system. Senator Lutchmedial-Ramdial also spoke about the matter of speed over quality. In other words, whether this legislation is sacrificing quality for speed. And Mr. President, that was never the intention. It's never the intention, because there are many safeguards in the criminal justice system, in the legislation, and many other pieces of legislation. There is procedural fairness in place to prevent any injustice from occurring, and the Honorable Senator knows this. With respect to Senator Maharaj's query about whether or not we expect all of the other cases, the thousands of cases that have to go through the High Court, whether they too will be subject to that standard, I think Justice Ramsume Hines was setting a standard with respect to the judiciary and how these cases are to progress, and the very strict timeline in which we expect and communicating to the public that justice is to be dispensed with. And that was simply it, and we accept that. We accept those improvements. So the bill, of course, makes 2 amendments to AJIPA. But before, Mr. President, I discuss the mischief that the amendments are meant to cure, I wish to read into, just for a moment, into the record, something I read in a book called The Fundamentals of Caribbean Constitutional Law, at page 270, chapter 6, paragraph 12. And it touches on the rule of law. And the rule of law is very important to AJIPA, to the criminal justice system, and to the debate that we are undertaking. So it says, as distinct from the nature of legal rules, the rule of law in Caribbean constitutional law is understood to also make certain demands on how legal rules are administered by public officials, including judges. Officials must apply the rules in the sense that there should be congruence between the law in the books and the law in fact. They must apply the rules as they are and act within the four corners of the law, the ultra vires principle. Associated with both these concepts is the principle that public officials must not abuse their discretion or act arbitrarily, and they must have due regard for procedural fairness in applying legal rules. Finally, one of the core principles identified with the rule of law in Caribbean constitutional law is institutional. Courts play a critical role in ensuring the rule of law by hearing and deciding in a timely manner all justiciable claims, and they must embody the values of independence, impartiality in carrying out that function. Mr. President, it goes on to describe the core principles of the rule of law as legal certainty, legality and the ultra vires doctrine, procedural fairness, and access to justice. And under the core principle of access to justice as a tenet of the rule of law is the concept that the law must, everyone must be equally accountable before the law if rules are to be effectively and routinely obeyed. And in that very same book, at paragraph 6, at paragraph 21, chapter 6, on page 277, it says under equality before the law, it says from the Prime Minister down to a junior clerk, everyone is responsible for their actions before the law. The law must be applied without favor if access to justice is to be meaningful. But, Mr. President, I would add for emphasis that the law must be applied without favor, effectively, routinely, without delay, if justice is to be meaningful. And for many decades, the Honorable Attorney General has indicated, for many decades, justice in Trinidad and Tobago has not been meaningful. In fact, we know that the criminal justice system has been plagued with delays resulting from a severe backlog of cases, with thousands of criminal cases being stuck in the magistrate's court for over 10 years in some instances in a procedure called preliminary inquiries. This has caused considerable delay and severely crippled the criminal justice system. And if you ask the average man, Mr. President, whether or not justice in Trinidad and Tobago is seen, the answer would not be surprising. Access to justice is denied if access to justice is delayed. Senator Sunity Maharaj indicated that, of course, the harmful effects on whether or not justice is delayed, and those harmful effects are felt by the accused person who wishes to clear his name, the victims, the witnesses, but most importantly, it tarnishes the image of the administration of justice in our own criminal justice system. Delays in the criminal justice system over the past decades was and is not acceptable for this present government. The near collapse, as described by the Chief Justice, Mr. President, of our criminal justice system was and is not acceptable. And the erosion of the rule of law under our watch as a government was and is not acceptable. And it is for that reason that since 2015, this government, led by the Prime Minister and Attorneys General, have worked tirelessly to move massively away from the preliminary inquiry procedure to clear the backlog and to improve criminal justice in our society. So in December 2023, after years of consultations, as the Attorney General indicated, years of consultations with many stakeholders, including the judiciary, this government has moved to create that tectonic shift. And it has started in January of 2024, and we are all excited and anticipate a new, improved criminal justice system here in Trinidad and Tobago. Mr. President, the UNC promised to do it. They could not do it. The PNM has done it in Trinidad and Tobago. And the PNM would be recorded in history for many things. But if there's one thing of improving justice for the people of Trinidad and Tobago and improving that criminal justice system. So, 2 amendments to this bill, and we accept that as we go along, there may be some more tweaks to get rid of some unwanted lacuna that may have been, by oversight, overlooked. Some unwanted lacuna that would only be recognized and detected as we operationalize the new AJIPA bill. The ones before us today, the word given, so the subsection would now read, a signed original statement was recorded by a police officer or given by the witness. And it is amending Section 21 of the AJIPA Act, which deals with the admissibility of prosecution witness statements and the conditions that must be met. And we accept that not all witness statements are done by, recorded by police officers. In fact, in the other amendment, we are dealing with the whole definition of police officers. But a witness statement may be recorded or be assisted. A witness may record his own statement and sign it, or he may be assisted. And therefore, we do not wish the section as it is presently constructed to render any of these witness statements inadmissible. So we're including the word given so that a witness who may be assisted by a family member or by somebody else not mentioned or not described in the expanded definition of police officer, that those witness statements can be made admissible, especially now as the High Court is dispensing with thousands of cases in the backlog. The other one, we propose to introduce a new subclause in Section 21(9), which expands the term police officer to include not just police officers, but anybody who is involved under statute in investigation processes. And that is accepted. At present, there are a number of witness statements that have been recorded, reduced to writing by persons who are investigating tax matters in the Board of Inland Revenue, in the Police Complaints Authority, in Customs and Excise, and without the expansion of police officer in this definition, then those statements will become inadmissible at the sufficiency hearings and will be thrown out. So those are the amendments, Mr. President, that we have before the Senate today. They are very urgent and are very necessary. And in conclusion, Mr. President, this is a watershed moment in Trinidad and Tobago. We have done away with preliminary inquiries, and the judiciary is moving speedily ahead at clearing the backlog, at improving the efficiency of the criminal justice system, and improving the concept of justice and the rule of law for accused persons so that they can get rid of their matters, know their fate, if there are any adverse consequences, as quickly as possible, for victims who suffer emotional distress in wanting, and the families of victims who want to understand and know that these matters and justice has been meted out, and of course, for the concept of the rule of law in Trinidad and Tobago. So again, I commend the Prime Minister, the Attorney General under Mr. Al-Rawi, and Attorney General Armour for working diligently, wide consultations, and keeping at it to ensure that this legislation is passed along with others, because this is not a silver bullet, this is not a panacea, for ensuring that the legislation is passed, that the criminal justice system is improved, and that justice is seen in Trinidad and Tobago. With those few words, I thank you.
Senator Vieira.
Thank you, Mr. President. Just to be clear, we're speaking about number 3 of 2024, an act to amend the Administration of Justice Indictable Proceedings Act 2011. The reason I wanted this clarification is there are 2 bills before us today, and in his opening, the Attorney General touched on both, so there was a little bit of confusion. But we're talking about number 3 of 2024. There really is not much to say about this bill, which amends Section 21 of the Administration of Justice Indictable Proceedings Act, so I will not be long. In 2011, we sought to abolish preliminary inquiries and provide for sufficiency hearings before masters of the court. Under Section 21 of the Indictable Proceedings Act, which treats with the admissibility of prosecution statements, it is provided that the original statement should be signed by a police officer or witness. Well, this amendment makes clear that witnesses give or provide their statements, and they may do so, well, either verbally or in writing to law enforcement officers, to attorneys, or to other relevant authorities. Secondly, and as we have heard, the designation police officer does not cover or include customs officers and tax investigators from the Board of Inland Revenue, even though these officials have a very important role in the prosecution of certain offenses under the Proceeds of Crime regime. So the amendments at Clause 3 are intended to cure that deficiency or close that gap. As we have heard, the bill is short, it is innocuous, but it is important, at least procedurally. And so, paraphrasing Mark Twain's famous statement, I would have given you a shorter contribution, but I didn't have the time. And with those few words, I thank you.
Attorney General.
Thank you, Mr. Speaker. Mr. President, I beg your pardon. Mr. President, I could stand to speak at length because it is an area that I am very passionate about, but I am going to opt instead to be brief. And may I be permitted just to say a few words in my response. One of the points that was made by Senator Lutchmedial that I'm reluctant to, but I will respond to, is this suggestion, or the submission rather, that there is still a preference for the system that existed in preliminary inquiries where you need to test the evidence. Well, the short point in answer to that is that the evidence of a fair trial is going to be tested. Let's just think about what we are doing under a JIPA. Under a JIPA, someone is charged, and the documentation which provides the master with the evidence on the basis of which the charge was brought is brought before the master in documentary form, and there is going to be no cross-examination. You have to trust to your judges to apply the law, to be dispassionate, to be fair. The master is going to look at that documentary evidence and come to a determination of whether or not a prima facie case has been made out. Prima facie meaning whether there is sufficient credible evidence that persuades the master that on the offense charged, this person should face a trial at the assizes. Under the old system, we spent 6 to 10 years cross-examining all of the witnesses on that before the magistrate could commit to the assizes. And what suffered in that process was exactly the point that Senator Maharaj speaks to. The entire system got clogged. What suffered under that are the accused, the victim, the families, and the communities, because the process was never ending. Under a JIPA, the documentary evidence is assessed by the master. The master says no sufficient prima facie case, and that's the end of it. The case is thrown out. Or, as we saw in the case of the Sheldon Dooth North matter that I spoke to, within a matter of 4 months, instead of 6 to 8 years, the master says there is a sufficient prima facie case made out. And what is the next step? The next step, Mr. President, is a trial. And at that trial that takes place within a shortened run-up to the wicket, that accused will get the full benefit of a fair trial. His lawyer will be able to cross-examine before the judge all of the witnesses who seek to put him behind bars, and the case will either stand or fall on the veracity of the material evidence that is brought before the judge. So there is no compromise of the fair trial right in the process that a JIPA now brings to the fore. What is brought to the fore is that the accused is going to know in a shorter period of time whether he is going to spend his time behind bars or whether she or he is going to walk a free woman or a free man. What is wrong with that? A number of other points were made, Mr. President. Senator Lutchmedial takes credit for the fact that 2011 Act was the opposition's vision. Well, the 2011 Act was the opposition's vision. You know what came out of the 2011 Act? Section 34.
Yes, it's true, it's true, it's true.
What came out of the 2011 JIPA Act that the People's Partnership brought before the Parliament is that in the dead of night, one night when everybody was on holiday, they came back to Parliament with Section 34 to get their friends out of jail.
Sneaky, sneaky, sneaky.
For that vision, thank you very much, Mr. President. Thank you very much, Mr. President. So I could spend much time. Senator Lutchmedial also makes the point that there are staff constraints at the office of the DPP and other places. Well, the fact of the matter is that my office is hard at work actively seeking to fill vacancies at the office of the DPP. Yeah. Last year, we offered to bring, I wrote to the Commonwealth Secretariat, to Baroness Scotland. I got her agreement to engage with me, and I engaged with the DPP to bring Commonwealth lawyers to Trinidad to stop the DPP. The DPP said, no, thank you. We are now in the process of filling vacancies on short-term contracts. The Judicial and Legal Service is in the process of doing that. As we speak, vacancies are being filled. And as we speak, and I said this in another place, as we speak, there is a building that is being sourced so that the DPP will have a building to move into and to give him the spatial requirements that he needs. And at his request, we are currently making provision for IT facilities for the DPP. So we can't, with every innovation, we can't stop and say, well, we have problems, so let us not initiate the innovation because the problems are too much for us to bear. We have to move on. A JIPA is in place, and we are putting the systems in place. And therefore, I don't accept the criticisms that there is not sufficient resources or not sufficient will on the part of this government to work with all stakeholders to enable the judicial system, the administration of justice, to move forward. Mr. President, Senator Maharaj asks rhetorically, she hopes that this case, the Dudnath case, is not the exception. Well, let's look at life positively. This is one of the first cases that has come to court since a JIPA, which was passed in 2023, December 2023. The case was committed, was assigned, man was charged in January 2024. Let us take that as a signal of an optimistic passage into the future that we can do better. Yes. Why must we decry the first case that comes to trial and is demonstrably being managed in a better system that has been produced by a JIPA, as well an exception which we are not going to continue with? We must be positive. If we are going to move this nation forward, we must be positive.
AG, can I
Sorry,
can I ask
beg
a
your
question?
pardon, my back was to you, Senator.
I probably don't understand whether now that a JIPA is passed, does it include those, how many thousands of cases that were there before a JIPA was passed, and those cases that are waiting that long, will that affect those cases? Because I think that's one of the big questions.
To answer your question very briefly, Senator, in principle, yes, what is going to happen and what is happening under a JIPA is that the old cases that existed before will be brought before the master, and the master will do an assessment as to which can move forward and which have to remain in the old system. It's an ongoing process, and I know that from the information I have, and there is a unit within the Office of the Attorney General called the Criminal Justice Unit, and we work every day with the judiciary and every day with the police and the DPP's office. It is a moving target of achievement that we are committed to in collaboration with other arms of the state to make the system work. So the answer to your question, in principle, yes, but it will take some time because each case is going to have to be looked at on its merits. Thank you. Mr. Speaker, Mr. President, I beg your pardon. I was going to move next to touch very briefly on the question that had been made by Senator Lutchmedial. Would persons giving witness statements be familiar with the procedure? Given statements should not be able to be put into evidence. Well, training and sensitization on a JIPA has been in place and is being conducted by the judiciary in collaboration with the Criminal Justice Unit of the Office of the Attorney General since 2023, prior even to the proclamation of a JIPA. And all of the stakeholders are engaged. All, the police service, the prison service, the Office of the Director of Public Prosecutions, the public defenders who are part of the Legal Aid Authority, and it is an ongoing process. Mr. President, I could continue in detail, but I don't think that, I think I would overstay my welcome in speaking too much. So with those few words, I beg to move.
Ooh, Honourable Senators, the question is that a bill entitled an Act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Thank you very much, Mr. President. In accordance with Standing Order 66-1, I beg to move that the Administration of Justice Indictable Proceedings Amendment Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Senators, the question is that the Administration of Justice Indictable Proceedings Amendment Bill 2024 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay, honourable senators, as we are well aware, this particular bill has 3 clauses. I've seen no circulated amendments. As such, we're ready to begin. Good.
Can I just take one last one? You can maybe just ask one. Yeah. Clauses 1 to 3.
Honourable senators, the question is that clauses 1 to 3 stand part of the bill. Honourable senators, the question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stands part of the bill. Honourable senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Attorney General.
Mr. President, I wish to report that the Administration of Justice Indictable Proceedings Amendment Bill 2024 was considered in the Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable senators, the question is that this Senate agree with the committee's report on the Administration of Justice Indictable Proceedings Amendment Bill 2024. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed.
Honourable senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 4, Number 1, and the Criminal Procedure Act, Chapter 12, Number 2, in relation to the place and time for sittings of a court and to provide for related matters, be now read a second time. Mr. President, I am pleased to report to the House for the consideration of this Honourable Senate the Miscellaneous Provisions Administration of Justice Bill 2023, which seeks to do a very straightforward and eminently commendable couple of amendments to amend the Supreme Court of Judicature Act, Chapter 4, Number 1, and the Criminal Procedure Act, Chapter 12, Number 2, in relation to the place and time for sittings of a court and to provide for related matters. The bill before us was passed, Mr. President, with an amendment in the other place on Friday, 12th April 2024. As the Senate is aware, Mr. President, this government has partnered with various criminal justice stakeholders to ensure the more efficient running of the criminal justice system, as indeed we have just been discussing in relation to the other bill that has just been passed. This has led to the introduction of an amendment to various pieces of legislation to ensure that the appropriate framework is available to ensure the smooth operations of criminal matters both at the district and Supreme Court levels. Significantly, we recall, Mr. President, the onset of the COVID-19 pandemic in March 2020. And if I may indulge this House with my own personal philosophy, wherever there is a cloud, there is a silver lining. And one of the silver linings that we have inherited out of the pandemic was the fact that it challenged us to operate differently. And one of the ways in which we operated differently was, in fact, pioneered very actively by the judiciary, who broached that, who accepted the challenge with vigor and saw the transformation of court hearings relative to their location and format. Court hearings moved to online platforms, seeing virtual attendance of participants, including judicial officers, witnesses, and accused persons. So that today, in 2024, having, under this government, successfully withstood the challenges of the pandemic and are a healthier people, we now find ourselves with digitalized solutions which have remained with us that came out of the pandemic. And consistent with the government's mandate to continue the drive to full digitalization, we now have the proclamation of the Administration of Justice Indictable Proceedings Act, which has introduced significant changes of which we have already spoken. And therefore, against that background, we have to look at the existing legislation that we are here to amend today, Mr. President, and recognize that it does not adequately cater to those changing circumstances. This bill is one that is rooted in pragmatism to ensure that court resources are optimized, to enhance the flexibility for court proceedings by incorporating both virtual and hybrid appearances and designating more generalized regions rather than specific locations for filing complaints and hearing of matters. Importantly, Mr. President, where the specific location of an offense is unclear or where the utilization of discretion fosters judicial fairness, the bill also grants to the Director of Public Prosecutions the authority to file indictments at any designated registry of the Supreme Court for the Criminal Court Division in North Trinidad, South Trinidad, and in Tobago. Permit me, Mr. President, to take you through the short clauses of the bill. The bill contains 4 clauses. The first bill provides for the short title. First clause. The second clause provides for the commencement of the Act to come into operation on a date fixed by the President by proclamation. Clause 3 provides for amendments to the Supreme Court of Judicature Act. The proposed amendment to the Supreme Court of Judicature Act, Mr. President, addresses the critical issue with the existing legislation, which requires currently that all trials are to be held within the boundaries of San Fernando, Port of Spain, and Scarborough. It goes without saying that in this current technological climate and with the heavy urbanization of these areas, this significantly confines and limits the available spaces that the judiciary is permitted to operate within for any court function or court expansion. Put simply, the existing legislation excludes court spaces outside of the respective city boundaries. This presents spatial challenges. It also presents security challenges, as we are all aware of the risks posed to the general public in transportation of high-risk prisoners, if so required, into heavily urbanized areas for their court appearance and court attendance. But more importantly, the change that we are asking this August House to embrace today, Mr. President, by broadening the areas in which the court has the flexibility to operate physically and enhancing the court's capacity to deal with virtual and hybrid discharge of justice, we are taking the courts to the people. Mr. President, having regard to the urgent need for the judiciary to utilize all the resources at its disposal, as well as supporting the convenience and safety of judges, judicial officers, staff, accused persons, juries, and witnesses, the proposed amendments are not only crucial but necessary for the judiciary of Trinidad and Tobago. The proposed amendments are in line with the procedural changes within the judiciary that are in place and ongoing, and are crucial for supporting and maintaining the administration of justice throughout this proud republic. Permit me to expand on what this bill proposes to establish, Mr. President. Clause 3A of the bill amends Section 74(1) of the Supreme Court of Judicature Act, replacing the phrase Port of Spain, San Fernando, and Scarborough with the broader North Trinidad, South Trinidad, and Tobago. Clause 3B of the bill, Mr. President, amends Section 74 of the Supreme Court of Judicature Act to clarify that North Trinidad, South Trinidad, and Tobago, stated in the existing Section 74(1), will have the exact meaning as Section 3 of the Criminal Procedure Act, which already identifies these zones according to the cities, boroughs, and municipalities in Trinidad and in the island of Tobago. Mr. President, Clause 4, amendment of the Criminal Procedure Act. Clause 4 seeks to amend Section 2 of the Criminal Procedure Act by inserting indispensable solutions. For example, in line with the current initiatives and practices of the judiciary, phrases such as the establishment of the Virtual Access Customer Centers, VACCS, VACs, phrases such as hybrid mode and virtual mode have been introduced in Clause 4A to reference the conduct of proceedings before the court in part virtual and electronic means. Mr. President, this inclusion was considered necessary as the existing outdated legislation failed to address the current measures undergoing in the judiciary to digitize the courts. Clause 4A similarly introduces other phrases such as in person to distinguish the conduct of a hearing in a court building in the physical presence of the judge, master, district court, judge, or registrar who is adjudicating. Permit me to mention, Mr. President, that Clause 4A additionally provides for the clearer definitions of North Trinidad, South Trinidad, and Tobago. So we now know that North Trinidad has been defined to consist of the city of Port of Spain, the boroughs of Arima, Chaguanas, and Diego Martin, and the municipalities of San Juan Lavantil, Tunapuna, Piarco, and Sangre Grande. South Trinidad will consist of the city of San Fernando, the boroughs of Point Fortin and Siparia, the municipalities of Cuba, Tabaquite, Talparo, Pinal Debe, Princestown, and Miaro Rio Claro. Lastly, Tobago would encompass the entire island of Tobago. Mr. President, Clause 4B amends the Criminal Procedure Act by repealing Section 3 and substituting a new Section 3, which provides for changes to the law on the following: place, time, and modes of trial in North Trinidad, South Trinidad, and Tobago; attendance of judges and judicial officers for the hearing of cases virtually, in person, or in hybrid mode; the designation of a place for a registry of the Criminal Division of the High Court; and practice directions for proceedings, documents, or any media to be filed at the registry. Mr. President, this significant amendment will empower the Chief Justice to appoint places and times for trial by order, providing for an exception that a judge or judicial officer may hold sittings at times and places other than those appointed by order of the judiciary where deemed necessary and in the interest of justice. Clause 4C, Mr. President, beg your pardon, repeals and replaces Section 4 of the Criminal Procedure Act. That clause provides that where in any written law reference is made to Port of Spain, San Fernando, or Scarborough as the place where criminal trials are heard, they are deemed now to be a reference to North Trinidad, South Trinidad, and Tobago, respectively. It is clear, Mr. President, that these amendments to these pieces of outdated legislation in that regard are a response on the part of this government, and indeed driven by the engaged stakeholder consultation which we continue to have with the judiciary, to the evolving societal needs and to the unforeseen strictures of the previously existing legislation. It is necessary to remove those limitations with respect to the use of court spaces. As mentioned previously, Mr. President, those proposed amendments are pivotal in supporting the judiciary in its mandate of furthering the principle of the efficient administration of justice and the ease of access to justice for the people of Trinidad and Tobago. Significantly, Mr. Speaker, Mr. President, I beg your pardon, the proposed amendments will address organizational and divisional needs of the judiciary, support case flow management, and case management strategies. Importantly, the bill contemplates the change of case flow management as seen through our Administration of Justice Indictable Proceedings Amendment Act 2023. There is already an increased flow of matters moving from the district courts to the high courts, and it is of critical importance that with the increase in filings, suitable accommodation across North Trinidad, South Trinidad and Tobago are permitted, as well as allowing for the utilization of virtual hearings. I would like to assure the citizenry of Trinidad and Tobago and this Honourable House that this government is committed to continuing to bring effective and necessary legislation to this Parliament, which upholds the principles of the administration of justice and separation of powers with an interoperability of collaboration between the arms of government, and to uphold access to justice, equality, fairness, and the integrity of all the citizens of this country. Mr. President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to amend the Supreme Court of Judicature Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Senator Lutchmedial-Ramdial.
Thank you, Mr. President. Mr. President, we are again debating another bill which seeks to make some procedural changes and to introduce some definitions that would incorporate and legislate for the things that we've been doing for some time now within the court system. A lot of it became necessary as a result of the pandemic. And so we have to make some changes to the Supreme Court of Judicature Act and, of course, the Criminal Procedure Act, recognizing that the importance of procedure in the entire system and ensuring that everything is done procedurally correct, because as one of the members opposite, the Minister of Tourism, acting leader of government business, would have read, procedural provisions and making sure that you have the right procedural provisions are just as important to the rule of law and the dispensation of justice. And so we must ensure that we get it right. So there's been a sort of a reorganization within the court system and a move away from the old concept of the assizes and where the assizes sit and so on. And the Attorney General used an interesting phrase about taking the courts to the people. And there are some mixed views about that. And there are still some mixed views about the conduct of virtual trials. And I think the Law Association has made some comments on it. And so I'm not opposed to virtual trials. I think that they serve a very useful purpose. And the bill does, in fact, preserve the discretion of a judge as well as the Chief Justice to make certain decisions when it comes to the conduct of in-person and virtual trials. There are some trials that lend themselves to a virtual process by necessity. There are some that are simply more efficient if conducted virtually. And again, I can say, for example, with the more financial type crimes, fraud matters, white-collar crime, definitely and certainly where the demeanor of a witness and so on, eyewitnesses and all of that, do not come into play. We can certainly utilize the virtual space to have more efficient trials being conducted. So the law will now provide for that, but it preserves that discretion, and we must always have that discretion for a judge to be able to do what they feel to be in the best interest of a case, because no two cases are alike and circumstances may lend themselves to one way or the other. Another reason why the virtual mode and virtual conduct of trials or the moving of a trial from one location to the next might also better serve the interests of justice is, of course, when you still have jury trials being conducted, or whether it is because of the familiarity of people in the area with the particular incident, you may wish to move a trial from one place to the next. And those are some of the things that this bill would certainly allow for. The one thing that stood out, and I used the term just now, interest of justice, and I know that this bill has been around for some time. It was laid last year, and I think it was debated earlier this year. So I hope I have the correct version and that this wasn't changed before. But I noticed when the amendments to the Criminal Procedure Act, we are looking at the discretion of the judge, the DPP, or even the accused to make an application to transfer matters for trial from one of the designated places to the next. And the terminology, and we've spoken before in the last bill about consistency in terminology. And throughout this bill, whether you look at it, and I've highlighted some of the different places, when you look at clause 13C, we look at the interest of justice. When, for example, you have an offense that occurred virtually and the director has the discretion in order to file the indictment in either one of the designated registries, he must consider the interest of justice as one of the factors, and we're going down the road. But then when we reach to clause 16, I see the phrase being used, the ends of justice so require. And I don't know if there's a reason for that, so I'm just inquiring whether we haven't been consistent with the use of the term interest of justice in other bills which would have come here and have gone to committee and so on, and there's been much discussion about that term, interest of justice, and us using that term, interest of justice, consistently, because it encompasses many of the things that, or many of the factors that the judicial officer would have to consider. So I don't know if that's if there's a reason why we haven't used it there, but I would suggest in that particular clause 16, the new 16A under clause 4, that we change that to the interest of justice so require. I also find that in particular with this section, and what the section says, and I'll read it, it says, notwithstanding subsections 7 to 13, and without prejudice to subsection 4, the court on its own discretion or on the application of the DPP or an accused may transfer a matter for trial from one place designated under subsection 2 to another such designated place whenever the court determines that, and it says A, the ends of justice, which I think should be the interest of justice so require, B, having regard to all of the circumstances, it is desirable to do so in the interest of securing a more expeditious hearing and determination of cases. And then it says or. Now, when you say or, it means that an expeditious trial, and it comes back to my argument, expedition should never, to me, be a priority over the interest of justice or the ends of justice or whatever you want to call it. So I would suggest perhaps a reorganization of this particular section to say, having regard, A should be having regard to all the circumstances, it is desirable to do so for expedition. B, perhaps a particular place is more appropriate, having regard to, and it goes on to talk about the district courts. And then the word and the ends of justice or the interests of justice so require. Because at the end of the day, that should really be the catch-all phrase, that the interest of justice must trump all other considerations when you consider moving a trial. You see, before it was, and in the way of thinking, and when we talked about trials being conducted before a jury of one's peers and all of that, the thinking was that the locality of the crime should have some connection to where the trial is conducted. And we are moving away from that way of thinking for various reasons. Again, as I said, too much familiarity in a small society with people, with the accused, with the witnesses. Because of witnesses being fearful, they may wish to be removed from the community and giving evidence in a district that is further away, when we have victims of human trafficking who may be in witness protection. There are a multitude of reasons why we may want to move away from that. But at the end of the day, interest of justice must always trump the rest of it. So I don't disagree with the policy behind what is proposed here, but I just think that a little cleanup there to make sure that interest of justice is an and not an or, and that expedition or the interest of justice or the ends of justice is not something that should be considered. That's just a minor cleanup on that one there. It would be remiss of me if I didn't put forward a couple of things that have been discussed when it comes to this division of the judiciary now between the North and the South and Tobago. We are now using what is really the regional corporations to divide, and before it was what we call the magistrates' courts or district courts that we determined wherever a matter occurred and the preliminary inquiry went to that particular court, or the charge was first read at that court, would determine where the indictment had to be filed. So everything from Hoover to Mayaro to Point Fortin ended up being filed in the San Fernando Assizes. Everything from Chaguanas to Port of Spain and as far east as Sandy Grande ended up in the Port of Spain Assizes, and Tobago was Tobago. We're now using the corporations, and we've divided them along similar lines between North Trinidad, South Trinidad, and Tobago. And it would facilitate, for example, having trials being conducted at the Princestown Court when it should be, matters which would have traditionally gone to the San Fernando Assizes. And that's very useful because we have no San Fernando Assizes. The building has been closed for a very lengthy period of time. We've been hearing for the longest while about the construction of a new district court in that area. I remember in the first budget debate that I participated in this particular place, we were told that by the end of 2021, it would have a new district court at the corner of Irving and Sutton Street in San Fernando. Well, that building or that structure, which I think is only consists of a few pieces of iron and what looks like half of a foundation, is now covered in vines. And I think it is important because the legal profession continues to be very concerned about the availability of space and the availability of resources, particularly in some of these areas when it comes to the conduct of trials. We've been utilizing, in order for physical trials to take place, I understand, on the criminal side, they've been using the facilities at O'Meara. When you have, and this is just the reality of the profession, when you have San Fernando practitioners, albeit the option for virtual is there, but when you have to utilize facilities at O'Meara, it is quite challenging. There's just a physical challenge sometimes with how we operate. There was a time when I first started practicing when the Court of Appeal sat in San Fernando once for the month, or perhaps every other month, that they would sit and hear appeals coming out of San Fernando, civil appeals at that building. We no longer have that happening because the building is closed and we don't know what's going on there. So right now in San Fernando, I think there are 3 functioning courtrooms in what is known as the Medina building, and all matters are being dealt with there, or they're being moved to Princestown or O'Meara. And I mean, that really is a challenge, and it's not, and I understand resources and these things take time and we have to get it done. But we ought to really look at ensuring that we don't just say, well, we can do everything virtually and therefore neglect the physical. We still need the physical and we need it to be there. Towards, when we talk about taking crime to the people, the virtual space is seen as more convenient, particularly to a lot of lawyers who don't want to have to physically be present in a courtroom in order to deal with, especially when you have little procedural things and hearings and all of that. But there's been some concern by the Law Association about access to persons outside of the police, the witnesses, and the judicial officer, and the DPP's office, and so on, to criminal trials. And they've made the point that criminal trials are supposed to be public hearings. And I have heard a couple of complaints coming from the media, particularly about their ability to access and give appropriate coverage to trials, whether it's civil or criminal. But there's a particular interest, and we can't simply dismiss the public interest in criminal trials. Again, I remember wondering why there were some people at the San Fernando Assizes sitting there day after day listening to a trial, how they were connected to a matter, only to be told at some point in time by the police in those trials that these are just simply members of the public who were interested and wished to observe a trial. And if you move virtual to this virtual space and we don't have those things taking place, for example, the victim's family. If a victim has to give evidence and is doing so virtually, can the family be there to support in the same room as the victim who might be giving from a virtual access center? Are they allowed to log on and observe what is happening? Those little things, and these were raised by Law Association in some submissions that they made when we were looking at the criminal justice system before JSC. They also raised the issue of just the wider public being able to observe, and I've included into that the media, because the media have complained that the links to various matters are not made available to them. Although they have the ability to request it, they have to know and to understand. They have to know what is happening on a daily basis. Make the requests. The requests are not sometimes dealt with expeditiously, and they are not afforded the opportunity to be able to log in, so to speak, and observe what is happening. Another thing some people find a bit disconcerting is just the operation of a virtual trial when you have technical issues. People tend to think it's challenging, again, especially when you're giving evidence and witnesses and so on. I conducted an entire civil trial virtually, and it was a heavy matter in terms of the amount of documents and so on that the witnesses had to refer to. And it really was challenging. It wasn't beyond the capacity of persons to get it done, but I could understand why people from time to time may have issues with those things. So I want to say that that discretion to be able to determine whether or not a trial should be conducted virtually or in person, it does belong with the judge who is seized of the particular matter, and it does really, it should be. But we shouldn't have a situation where we allow our physical facilities to be unavailable to the point that judges are forced to do things virtually or have a delay. And I think that has happened for some time, and I specifically will make reference to San Fernando because that's been happening quite a bit. And the Assembly of Southern Lawyers complained, and it was carried in the media, complained that they weren't consulted about the closure of the San Fernando court building. And then the judiciary responded by way of press release to say, well, we consulted with the Law Association, only to have the Law Association respond and say, well, there was a meeting where the issue was discussed, but we wouldn't say that was consultation. And these little issues, again, leads, to the public perception that sufficient consideration isn't given to all of the stakeholders who have an interest in these matters. Because access to a courtroom is not just about a trial, It's being able to physically go to the registry and make an inquiry. It's about being able to physically go to office copies because you've been waiting 6 months for a response to an email where you try to get the copy of a document that you need and you can't get it, but you can't physically access a building to go and meet a human person and speak to them. And those little things, as much as they may seem petty and they may seem to be, by the way, and little issues to iron out and maybe personal things, they affect the long-term administration of justice. I'll give you an example. Certification of fees for attorneys who do legal aid matters has been languishing for such a long time through the district courts, and they have been unable to get adequate feedback from the courts because you can't physically go into the court and speak to a physical person, and you send emails and you get a generic response. That in certain areas right now, we have no attorneys willing to take on legal aid matters. And that's a serious thing. Legal aid and the Legal Aid and Advisory Authority is a major stakeholder in the criminal justice system. And so, if we don't pay attention to all of these things and we simply say that, look, everything could be done virtually, we're going to have issues such as this arising. So I raise those matters. Of course, the basic, the most specific thing that I would say about this bill is that I would like to see the consistency of interest of justice being used, that term, because of, again, that term and what is encompassed by it would be something that we want to see consistently across all bills dealing with the administration of justice on the criminal side, and taking into account how we operate and the decisions to be made whenever a discretion is to be exercised, whether it's by the DPP, the judge, the Chief Justice, or whoever it may be. And I would say that on that particular subsection 16, that I would want perhaps to change that ought and a restructuring of that section, because interest of justice ought to be the catch-all and should be incorporated into all decisions being made when a trial is being moved. Whilst it may seem unlikely, we don't want a situation where an accused person says, my trial was moved, and the judge exercised a discretion under Part B to say it was for an expeditious trial, but overall the interests of justice weren't served, and for whatever reason, it wasn't served, whether it is the availability of the witness or whatever it is. The law, as it is being proposed and it is being envisioned, will have many benefits. I cannot disagree with that. We can have witnesses who are out of, you know how much trouble, it's real trouble when you have witnesses out of the jurisdiction and you're trying to move a criminal trial forward. Police officers who go on 1 year and 2 years leave, sometimes they are out of the jurisdiction and a criminal matter cannot proceed in the High Court because of that. This bill, I hope, will cure that, and I hope that it is utilized properly to cure some of those issues that we have faced for a long time in the criminal justice system, and to afford an opportunity to witnesses who may wish to travel, who may be studying abroad, victims, and so on. But we don't want to do it to the exclusion of the wider public or to the exclusion of any other person who might have an interest in being able to observe, to follow, to participate, for example, in a particular trial. Pause for a moment and consider, for example, at the end of the prosecution's case, where we decide where a decision is made in the interest of justice to protect witnesses or to facilitate a witness for the prosecution who is out of the country, a victim or somebody else who might have migrated, that the decision is made to have a virtual trial. And at the end of the prosecution's case, you have a no-case submission, it may be overruled, and the defendant is called upon to put his case that he wants to now utilize a witness who, for some reason or the other, the format of the trial that is chosen may not be in the best interest of him, or it may not be possible, or something to that effect. So we have to manage trials with all of the stakeholders from the beginning to the end in a way that would serve the interest of justice. And again, the need for expedition is a major factor, but it would not be, it wouldn't bode well for justice if it is placed above the interest of justice. So interest of justice for all parties involved should really be of primary consideration. And I think that apart from that, there are no other sections here. They are all very administrative in nature. We are now changing, again, in the Supreme Court of Judicature Act, the references so that we have consistency. Consistency is good, consistency is important, and we would have the North Trinidad, South Trinidad, and Tobago being imported now into the Supreme Court of Judicature Act so that there's consistency between that and the Criminal Procedure Act. And that is it is certainly not objectionable. I know that they have also introduced a definition called a hybrid trial. I know on the civil side we have conducted some hybrid trials in the past. Again, this requires that courtrooms be sufficiently outfitted to do a hybrid trial, because you could have a physical trial taking place and then there's maybe one expert witness or something that you want to use who's out of the jurisdiction, and you'd want to have the hybrid in that case of having this person to be able to use the virtual mode. So we have to make sure that we have those facilities all available on the criminal side. I think there are now but the entire Hall of Justice is supposed to be used for criminal trials, save and except the Court of Appeal on the 3rd floor. But I don't know where they have reached, but I hope that we will continue to roll out that implementation of technology in all the criminal courtrooms so that we can, because I think hybrid trials will become the future of criminal trials in this country in all cases. And so again, the government hopefully will ensure that that process of resources and so on being made available to the judiciary continues as we upgrade the facilities at all the courts, both in Port of Spain and in San Fernando, because we are suffering in San Fernando. I was happy to see today in the media that the government might be considering some alternative representation that was here but it left for San Fernando. But hopefully that my good colleague, wherever he is in the building, he's listening, because I understand he might be taking on a very important role in San Fernando. So that he probably, so. And if that is the case, I hope that the sufficient attention is paid to that particular court, because it really is sad. It's very sad to see. It's very sad to see that that building that we had our 3 criminal courts in San Fernando and has the capacity to really serve the people of South Trinidad in the most convenient way. And I could say that. It's nice to talk about court in Faizabad and court in Princestown and all of that, but the fact of the matter is, if you serve the profession and the people who are affected in the criminal justice system of South Trinidad well, it requires that sufficient attention be paid to ensuring that those resources, as well as the district court in San Fernando, comes to fruition, and that it's a project that is completed. So I look forward to that. So thank you very much, Mr. President, Vice President.
Senator Dr. Dillon-Remy.
Thank you, Mr. Vice President, for allowing me to make a brief contribution to this Miscellaneous Provisions Administration of Justice Bill 2023. As I was reading the bill, the first question that came to my mind is, why are we talking about putting legislation now for virtual courts? I thought those courts were functioning a long time ago. And I'm hearing from the Attorney General now, they were functioning, yes, before COVID, and it was accelerated during COVID, but this is now an opportunity to put it in the legislation, and for that I am quite happy. The bill is 4 clauses, short, long, but I will only comment on clause 4. And Clause 4A of the bill inserts the definition in line with the current initiatives and practices of the judiciary, which is we're currently dealing with virtual courts, etc. Clause 4B provides for changes to the law on places, times, and modes of trial from North Trinidad, South Trinidad and Tobago, attendance of judges and judicial officers for the hearing of cases virtually, in person, or in the hybrid mode, and the designation of places for Registry of Criminal Division of the High Court and practice directions for proceedings, documents, or any media to be filed in the registry. Clause 4C provides where reference is made to Port of Spain, San Fernando, or Scarborough as the places where criminal trials are heard, and heard in any written law. They are deemed now to be a reference to North Trinidad, South Trinidad, and Tobago, respectively, so it's all procedural. With respect to the introduction of virtual and hybrid definitions into the legislations, as I said, courts have been sitting virtually and hybrid. My understanding is at least 8 years, and guided by practice guidelines issued by the judiciary, but they are now being placed on the legislation. Mr. President, Vice President, I applaud the continued digitalization of our country through initiatives such as these, which generate significant benefits for the administration of justice as well as the citizenry. And Senator Lutchmedial pointed out in how many areas, and also the Attorney General, where the benefits from this initiative is now benefiting the citizenry and will continue. I would just like to just mention a couple points, though, about the virtual proceedings. And I read this article published in Northwestern University Law Review, Volume 115, Number 6, in 2021, written by Alicia Bannon and Douglas Keith. It's titled Remote Court, Principles for Virtual Proceedings During the COVID-19 Pandemic and Beyond. And again, I am very happy that we have taken learnings from COVID and we are running on steroids with it in terms of administration of justice in this case. And I quote from the article, remote proceedings can bring substantial benefits in some circumstances. Foremost, they have allowed courts to continue operating during the COVID-19 pandemic, reducing risks to court staff and court users alike, while providing essential services. But in more normal times as well, courts can use remote tools to strengthen the justice system, as we are doing right now. And the quote continues, remote court can make it easier for litigants to access the courthouse, enable legal providers to reach difficult-to-serve communities, allow attorneys to spend more time serving clients and less time to transit to the courthouse, and provide services to self-represented litigants, among other benefits. The COVID-19 pandemic has forced unprecedented agility, creativity, including the embrace of remote court in many contexts. Courts should not go backwards. But just as the court should resist the temptation to return to a broken status quo, they should also avoid embracing change without fully reckoning with the costs. And it is here that some of the points made by Senator Lutchmedial I would also seek to mention. In consideration of the aforementioned plea of Bannon and Keith to consider the cost attached to this change, I wish to briefly highlight three concerns. One, the infrastructure, and the virtual access centers have been mentioned, and the adequacy of them, but infrastructure is also dealing with the access, the adequacy of the internet, etc. And a presentation at the first International Conference on Law, Human Rights, entitled The Effectiveness of Virtual Trials for Criminal Proceedings as an Effort to Mitigate the Spread of Coronavirus During COVID-19 Pandemic by Jamila, Rampe, Gadding, and Hayadat was published in 2021 in the Atlantic Press. Advances in Social Science, Education and Humanities Research, Volume 549. The research paper explained that appropriate and suitable facilities and infrastructure that support the technology will be needed to connect the parties and to make sure that all of them could communicate optimally by being able to see and hear each other. Several facilities and infrastructure are essential in the process, including laptop or LED TVs, camera, microphone, and speaker. And here we're talking about infrastructure. The judiciary provides virtual access centers for members to the public to access courtrooms. And the Attorney General mentioned that the court is being taken to the people because, from what I understand, these access centers are in several areas of the country, including 3 that are in Tobago. Mr. President, in light of this information, I must ask, because there are some issues with the virtual access centers, as the Law Association had submitted something concerning the adequacy of them. In other words, they were concerned about the size and also about the comfort of people sitting in them. I don't know whether this is of how important it is, but I would just like to find out if there's anything going to be done to address the requirement for additional infrastructure. Another point is the access to justice. And again, this is some of the points that have been made by Senator Lutchmedial already. Inherent in one's access to justice is an individual's right to a fair hearing.
and persons should not be denied that. The research of Bannon and Keith revealed several shortcomings of remote trials which may be a hindrance to the fulfillment of that right. And that includes issues related to the digital divide, the access and comfort which requiring remote technologies are issues arising out of the continued digitalization of our country. And while I commend the judiciary for implementing the virtual access centers, which will now access the technology, however, litigants, whether self-represented or otherwise, who do not have the required technology, should be presented with clear guidelines and guidance as to about the virtual hybrid process. They should also have ease of information and resources which should otherwise be available inside the physical courthouse. Senator Lutchmedial made that point where persons, they're supposed to have a virtual hearing, and they're having difficulty getting that link, and they are phoning the judiciary and not getting responses. They are emailing and not getting an adequate response, and people are concerned. In the other place where you have the courts, they will be able to go in and get the information, but they have to wait now. So we are talking here about the digital divide and making sure that persons have the access that is necessary. The article from Bannon and Keith also talked about, and Senator Lutchmedial mentioned, that poor audio quality or video quality and poorly positioned camera have often made it difficult for participants to follow proceedings. Article continues, thus courts should develop policies and processes to ensure that to protect litigants when they cannot be heard or cannot hear at a critical juncture in their case, ensuring that they are not penalized for technological difficulties. Courts also need technical support on call for court staff and for members of the public, some of whom may be using the court's chosen remote platform for the first time. So, Attorney General, it's just a matter of saying as we roll it out and as we develop these are areas that we have to make sure that in the quality of the systems that are being put in place could be maintained. And it's not just that we have a venue that's closer to the person, but the quality of what is given there is not right. And I would imagine that Senator Bacchus would probably be one making sure that that is happening. Another point in terms of the digital divide, another point is the evidence testing. Reliability of evidence is established by subjecting it to rigorous testing. And one of the papers suggested by Rompi, Ganding, and Hayadiat explained that the main problem found is that the poor internet connection causes the examination to be less effective. And additionally, it is difficult for the judge to access the witness's psychological expression and gesture, considering whether that he may be under pressure in giving testimony or that he may be directed by another person in providing information because of his presence virtually. There's also the transparency that Senator Lutchmedial has spoken about in terms of not having the public being able to access these criminal proceedings. Courts like the CCJ provide live streams on their YouTubes for trial. However, many of the other courts have not provided any form of public access. And the transparency via online platforms also come with a privacy cost. And the article by Bannon and Keith went on further to explain, while in-person proceedings are open to the public, broadcasting court hearings over the internet introduces a loss of practical obscurity. It could be painful to know that anyone could view, potentially disseminate images from such proceedings. Further, if public access to proceedings is too unrestrained, courts also risk undermining the laws that allow for certain criminal cases to be sealed and records to be expunged. After all, it is difficult to prohibit recording a court proceeding
from the comforts of one home. In other words, something that may be considered private may be able to be recorded at a private location. And last point, D, courtroom management. This article by Bannon and Keith found that remote courts poses challenges for judges to manage their courtrooms and ensure fair proceedings. Remote technology offers new opportunities for distraction and inappropriate conduct during court proceedings, and it can be difficult for judges to identify such conduct and intervene. The judiciary issued the practice guidelines for electronic hearings on 21st of April 2020 and is helpful in directing some of the operations in the virtual court. However, I'm advocating to make sure that the procedures, the guidelines are continually updated to make sure efficiency, effectiveness, and the protection of right of a fair hearing and furtherance of the interest of justice. And I think the Attorney General will have mentioned education of the public about all these new systems, and clearly more education has to happen as you roll out the systems. With the rollout or implementation of any new system comes the need for requirement of education and access to information about how to effectively navigate the system. And I'm suggesting, as this excellent plan is rolled out, that there be more public education on the matters as to how this system can be accessed. Mr. Vice President, with those few words, I thank you.
Senator Bacchus.
Thank you, Mr. Vice President, for recognizing me. I just want to make a quick contribution, and it's really prompted by some of what my colleague Senator Remy has said and some of what Senator Lutchmedial has said relative to the technology and the things that surround it. I'm fairly sure Senator Teemal will also have some pieces to add to that, knowing his engineering background. But there are some things that I want to set on the table to make sure that we're not making an assumption that some people make. That is that the technology is a panacea and a silver bullet to solve all the things that we have. The technology is here to help us. The technology is here to make things simpler. It's here to make things more convenient. It's here to put us in a position where things that would have been, in some cases, impossible, now can become a reality because of the use of the technology. But the technology still has to be taken into the context of the things that support it. And I think the article you quoted from Senator Remy spoke to a number of those things. What we also have to remember is that what affects technology in the new sense also affects technology in the old sense. What do I mean by that? There was a time in this country when power outages in local areas were fairly frequent. If you had a court in that area, more than likely it affected it to such a point where the court could no longer function. If you put supporting infrastructure to support the court, backup power, UPS, the things that will make the court run, air conditioning that will run on that kind of power, then the court can continue. But it is the same infrastructure that will support the technology that will allow for this virtual environment to also continue. So the things that were hindrances in the physical world without the addition of the technology still will be things that could affect the world with the technology. But if you fix them in that space, you fix them in the technology space as well. So the requirements for what I like to call the resilience of service. And when I say the resilience of service, the court is one place, but the service that's being provided is what is happening within it. So the resilience of the service is for the proceedings to be able to continue, for the court to continue to sit, even in the advent of things happening around it that would normally stop it. That now becomes part of the prerequisites for the establishment, for example, of the remote areas that you were talking about, the remote courts. So you would find that if courts are being put into areas, or these virtual things are being put into areas that are remote, and that is what we intend to do, then the supporting infrastructure to allow for it to continue, for the service to be resilient, now has to be part and parcel of the design if the intent is for it to continue to work. So that is something you'll have to consider. Another thing that was there that we talked about is the suitability of the technology itself within the court. The cameras, the recordings, the microphones, the storage devices, the things that will allow for the persistence of the data that is collected, the safety of the documents that are uploaded. All of those things are already being considered and have to be considered in the technology application. It is good that we do have the empirical evidence of courts being able to sit, because we know that now. They're happening already. We're taking this a bit further. And some of the hybrid sittings that will become commonplace will require that we add specific technology in there to ensure the security and the ease of use, etc. But as with any new transition and as with any digitalization process, the four things that we have to consider remain the same: the people, the process, the technology, and in this case, the regulations that go along with it. We must address all of those in unison for this to be successful. So while I hear the emphasis significantly on the technology, the other things are there. Senator Remy, you did mention in the article about the things that would make it successful: training, familiarization, the educational aspects of it, the confidence building aspect of it, to ensure that people believe that when they do these things, it will work. All of those things are part and parcel of the people piece. The process piece is to ensure that the new regulations, the rules that surround how you operate within those environments are set. That has to be done. And the guidelines that are already set by the judiciary are there, and they will have to be expanded and continuously reviewed as we do that, because continuous improvement is a key component of that. The technology will see about itself. We are not the first, second, third, or 20th people to be embarking on this type of thing. The industry-grade technologies, they are well known, and the installation and the operations of them will have to be there. The additional piece is that the support staff that now support court proceedings now also include digital people. So when things don't work, if you need something in court, there are always people there to help you. You will need to have those type of health services available to you as well in the court systems. Those are the things that you have to consider. And then, of course, the main thing at the end of that is just the acceptance of it. And I think if we put all of the things that I've spoken to together and we expose them to the people who are going to be participants in it across all, the litigants, the complainants, everyone, once they understand and start to build the confidence in it, I think the usability and the fear of it will go away. So it's really us managing the softer skills, implementing the technology properly, understanding the risks and mitigating against them from the beginning as we are doing now, making adjustments to the guidelines, and then continuing to educate and familiarize. And I think this will work quite well as it relates to that. Mr. President, I thank you for the brief intervention.
Senator Deoroop, Teemal Deoroop.
Mr. President, I thank you for the opportunity to contribute to the matter before us. And first of all, Mr. Vice President, I would just say that I identify with my senatorial colleagues who have spoken before me on this bill. Senator Lutchmedial and then Senator Dillon-Remy did raise concerns or express views. Senator Dillon-Remy in particular about the technology part of this that would come about as a result of this bill. And I appreciate the contribution from the Honorable Minister of Digitalization for putting the concerns in a certain perspective. So that has preempted a fair amount of what I was going to say, so I won't go there. I will just stick to some of the basic aspects of the bill, some minor observations on my part, and seek clarification on them. from the Honorable Attorney General or other persons who will be contributing to the debate from the government bench. Mr. Vice President, Section 2(1) of the Parent Act of the Criminal Procedure Act states that in this act, registrar, deputy registrar, and assistant registrars mean the registrar, deputy registrar, and assistant registrars appointed as such under the Supreme Court of Judicature Act. And what we are seeing in what is before us in Section 4A(1), the amendment before us removes registrar at the beginning of the section. And thus, the amended section reads, deputy registrar and assistant registrars mean the registrar, deputy registrar, and assistant registrars appointed as such under the Supreme Court of Judicature Act. Mr. Vice President, it may seem a bit basic, but I'm a little puzzled by that amendment, because we have registrar at the beginning of the Parent Act. We have removed register from it. That is how I interpret the amendment. And I'm wondering what is the purpose for this amendment? What is the particular purpose of it? And what are the outcomes the amendment is supposed to achieve? Then in the same section, Section 4, virtual mode, there's an interpretation for virtual mode. And in the ending of the section, of the interpretation for virtual mode, the words facilitated by the use of technology under the management of the judiciary of Trinidad and Tobago. And I just have some concerns about the term, using the term management of the judiciary of Trinidad and Tobago, and actually putting the word management into legislation. And I'm wondering if we should not have replaced management with authorization. Because in terms of management of the technology by the judiciary versus authorization of the technology by the judiciary, I think from a legal perspective, there may be some implications if the technology is not actually brought into effect under the authorization of the judiciary rather than the management of the judiciary. I'm still on Section 4, Mr. Vice President. B, Section 13. And it says that in circumstances where an offense has occurred virtually. And in the bill that is before us, I looked for an interpretation of the term virtually. And there is no definitive interpretation of virtually. Now, if there is an interpretation under any other act, under any other law, I think we should reference that to bring clarity. But just the word virtually popping out at us under this piece of legislation, I think we need to nail it down a bit in the context of all that has been discussed here. And there should be some cross-referencing to existing law, or if not, we should address it in this particular piece of legislation. Still under Section 4(14), this section gives the judge or judicial officer the means to order a trial to take place in North Trinidad if that officer is satisfied that, and there are three conditions. A fair trial cannot be held at San Fernando, and I think a correction has to be made there, just a minor correction. San Fernando should be replaced by South Trinidad to be consistent with what we are looking at. And it is more the second thing, it is more convenient to the parties to hold the trial in North Trinidad. And in the interest of justice requires the matter to be held elsewhere. And it stops there. Now, I'm just wondering why there is no reciprocity in the provisions for South Trinidad and Tobago. Because this tends to say to me that a fair trial is only possible in North Trinidad. You know, why there is no reciprocity in that if the judge or the judicial officer thinks that it is not possible in the interest of justice and the other same three conditions outlined there, that a fair trial is not possible in North Trinidad, then why not can it be transferred to South Trinidad?
Vice versa.
Or, vice versa, or Tobago accordingly. So I think, you know, we need to look at that in terms of the reciprocity and have, you know, vice versa, as Senator Vieira is telling me, in terms of transferring. Yeah. I raised it in the context, my first thought was maybe there are special provisions in North Trinidad and the courts that are not available in the others, but I really wouldn't like to think in that direction. I would want to think that based on all that is happening and all the upgrades and everything that we are looking at, and the competence of our judges in all the different regions, that, you know, shifting of trials in the interest of justice should also include South Trinidad and Tobago. Now, Section 16, if you go a little further down, it does address transfers. It does address transfers under similar conditions that are outlined in Section 14. And it adds applications for transfer by the Director of Public Prosecutions or an accused. But I'm not sure if the provisions in Section 16 adequately addresses the question of reciprocity, as I have mentioned. So I would like the Attorney General to probably address it in his wrap-up and what his thoughts are on that particular aspect of it. Mr. Vice President, Section 3(7) of the Parent Act, the Parent Criminal Procedure Act, it outlines a procedure for the transfer of cases. And with respect to time or the number of days required for the warrants for transfer by the DPP, and then the serving of the warrant by the registrar. Some days are mentioned there. So there is a time period that is actually legislated for in the Parent Act. And what I've observed in this act before us, in the bill before us, there is no similar provision with regards to time. So I'm wondering if it's a deliberate omission, and if it is deliberate, then what are the reasons for it, for leaving out the time frame for transfer? And because we are repealing the entire Section 3 of the Parent Act, and if we do not address this, it means that it will no longer be in law. So I'm suggesting that the reasons for it, if I can get some of the reasons for it, why it is being left out. Mr. Vice President, still with Section 4(b), Section 18, which states that subject to any special or general directions by the Chief Justice, from time to time, a judge or a judicial officer may hear matters virtually, in person or in a hybrid mode. Now again, I raise the question of the term virtually, because as I mentioned before, the interpretation of the term under law, it is not there in this bill on whether we need to cross-reference it to existing law. But in this bill before us, we do have a definition for virtual mode. virtual mode is there, defined earlier in the bill, and whether instead of using the term virtually here, that we should actually use the term in virtual mode rather than virtually. So it ties in with what has been defined in the early part of the bill. And Mr. Vice President, with those few words, I must say that in terms of Senator Lutchmedial, the term "in the interest of justice" being used consistently across our various, our various bills, I would tend to agree with that. I think in the interest of justice, it would ensure consistency, and it covers, it would cover all the concerns that there would possibly be from accused persons as well as persons within the judicial system. Mr. Vice President, I thank you.
Minister in the Office of the Attorney General.
Mr. President, I thank you most sincerely for the, Mr. Vice President, I thank you for the opportunity to contribute to this debate, the Miscellaneous Provision Administration of Justice Bill 2023. Of course, a bill that seeks to amend the Supreme Court of Judicature Act and the Criminal Procedure Act in relation to the place for sittings of court and related matters. Mr. Vice President, as I begin my contribution to this debate, of course, because of how short this bill is, I would not want to run afoul of the standing orders and find my way running into, tedious repetition. So, of course, I would specifically focus on Clause 4B of this bill and particular new subsections that Clause 4 intends to introduce, and of course the policy behind the introduction of said subsections. But before I go there, Mr. Vice President, in my review of this bill, two major statements came to my mind: the coalition of the willing and all hands on deck. Throughout the course of this entire debate, on both sides, on three sides of this, on various benches, we have heard of concerns being raised about the administration of justice. And the administration of justice and the concerns as related to it, of course, is a perennial problem that, of course, concerns us all. And why I make mention of all hands on deck and a coalition of the willing is because this bill, in essence, shows our government's interest in working in tandem with the judiciary to provide the judiciary with all that it needs in order to ensure that we could improve the administration of justice in Trinidad and Tobago. And that term, the coalition of the willing, I take no credit for it. It's something that my brother Bacchus, Senator Bacchus, have always said to me. And, I believe, Mr. President, this is an opportunity where now, this bill, no doubt, it's something that the judiciary would have approached, that the judiciary wants. And our responsibility here now as the legislators is to work collectively with the judiciary to put into law and into legislation systems that, of course, will help them in the execution of their mandate as we all work together, both as legislators and as members of the judiciary, independent arms of state, working together hand in hand in order to be able to improve the administration of justice in Trinidad and Tobago. And I want to go to some profound words. And this of course, is not to simply be utopic, but my Attorney General, our Attorney General, spoke about positivity in his previous in the previous bill. And that positivity, Mr. President, is what is so critical for us to really be able, that mindset, and I come back again to the statement, the coalition of the willing, is what is so absolutely critical if we really want to improve the administration of justice system in Trinidad and Tobago. And to that end, Mr. President, before I jump into that clause 4B, and some of the new subsections that it intends to introduce, I want to take just a few little seconds or minutes to recognize the role that the independent judiciary has already played and continue to play in improving its own systems, in ensuring that we can move the judicial system in the direction and the administration of justice in the direction that will redound to only the benefit of every single stakeholder, stakeholders such as the accused, such as the victims of crimes, such as the court itself, such as attorneys at law who practice, who are officers of the court who practice, and more so, and overall, the public of Trinidad and Tobago. And, you know, why I want to recognize the judiciary is in preparation for this. I heard senators spoke about, Senator Remy in particular, spoke in her contribution. The Honorable Senator would have mentioned about systems, her concern and her hopefulness that there are systems already in place, or systems will be put into place by the judiciary to ensure that once operationalized, things such as internet, such as proper access to online platforms, all of that is available. And what I can say as a practitioner, of course, prior to entering into this new seat in which I sit in, prior to even the pandemic, the judiciary, to my mind, had started long before the pandemic of putting systems in place in order to modernize its systems and its processes. The pandemic, of course, expedited the rate at which some of its processes were implemented, no doubt. But as a practitioner of the courts, and any lawyer that sits here will have to agree with me that the judiciary, from the very get-go, years in advance of the pandemic, utilized subventions and allocations that were given to them, budget after budget, appropriation bill after appropriation bill, to improve its systems. And I have no doubt, there's no doubt in my mind, that by the time there is this full passage of this law, which now moves us from where these systems were put into place by practice directions and so on, and it's now legislation. I have no doubt at all that the judiciary would have done their homework and put their systems in place to ensure now that once the rubber hits the road, that the citizens of this country can benefit from what we are legislating and what we hope to legislate today. And so much so, I remember looking in preparation for this bill, I looked at a brochure that the judiciary made reference to on its website, and that brochure says the judiciary, in alignment with international best practice, is continuously working to ensure access to justice, equality, fairness and integrity, public trust and confidence, independence and accountability, expedition and timeliness. And throughout the length and breadth of that brochure on the judiciary's website, it also speaks to how and systems that were put into place or that are being put into place to be able to achieve each of these objectives. And I go back briefly again to the coalition of the willing. The judiciary has started putting into place its systems in order to move the administration of justice. And I can't speak again or speak enough about what the Judicial Education Institute, led by Justice of Appeal, Lucky, is also doing for improving the administration of justice through, of course, training for judicial officers, training for different entities. I've had the pleasure of working with JEITT to even come to Agla. I think it was about in 2018 it was right after I was sworn in, probably like 2020, late 2020, where JITT came in based on our request and trained members of our criminal justice unit based on my request, which of course was very beneficial. And all of these are the pieces that, at AGLA, the Honorable Attorney General can attest this. One of our mantras is bringing the pieces together. And while we deal with the legal part of it, we believe in bringing the pieces together. It's critical to work with all of the other arms of state. And this, Mr. President, Mr. Vice President, I could not jump into this bill without recognizing the independent arm of the judiciary and what it has already started to do in order to be able to move the administration of justice forward. Now, this begs the question, what part do we now play in that coalition of the willing? We too, as legislators, must be willing to work with the judiciary and other independent arms in order to be able to improve the justice system. Coming back again to the Attorney General's most profound words, we need to be positive about this. And of course, I'm hopeful that we will get the support that we are looking for, even from the opposition, as it relates to the passage of this bill, because no doubt we all agree that we each need to do our individual part in, of course, improving the administration of justice for the benefit, of course, of Trinidad and Tobago as a whole. Mr. President, as you know, Senator Dillon-Remy would have spoken also about infrastructure, and I was so grateful that again my big brother Senator Bacchus would have jumped in, because on my notes here I wrote digital transformation and highlighted it in green. So I'm grateful that the Honourable Senator, again, who is a specialist in his own right, a man again who I have the world of respect for, would have jumped in and dealt with those concerns. Senator Teemal would have raised also some concerns which during the substantive contribution, my substantive contribution, I would attempt to deal with a few of them. I would, the AG, I'm sure, will deal with many others. But in my substantive contribution, I would look at, in particular, the issue of virtual offences, because I know Senator Teemal would have raised his concerns with that. And then that whole, Senator Lutchmedial as well spoke about the whole issue of the interest of justice. I would deal with the new subsection 14 and 15 that clause 14B introduces. And at that juncture, I would look at the whole concept of the interest of justice and, as I continue my contribution. So, Mr. Vice President, with that being said, I want to immediately jump to clause, of course, in this bill, when we look at clause 3 of the bill, before I jump into clause 4, clause 3 of the bill, of course, is that section that seeks to amend section 74 of the Supreme Court of Judicature Act. And it's where, what to my mind, we are moving from the very specific to the very general. Section 74 is where we spoke specifically of Port of Spain, specifically of San Fernando, specifically of Scarborough, and we are moving from the specific to the general, which is now North, South, Tobago. And the Attorney General certainly would have dealt with that in his piloting. But the simple 2 pence that I want to add as it relates to the policy that drove this amendment, the simple 2 pence that I want to add, Mr. Vice President, is that instead of limiting, what we are attempting to do is to no longer limit the judiciary by the boundaries of San Fernando, Port of Spain, and Scarborough. What we are doing is giving the judiciary, by not, of course, moving from the specific to the very general, we are allowing legislatively the Chief Justice now in the administration of justice to be able to make prudent decisions. Decisions, of course, are based on real-time concerns as it relates to where courtroom sittings are heard, where trials are heard, of course, the time and place of hearings, and, of course, not limiting the judiciary. And I know, of course, the Attorney General would have spoken about that. If I may give a live example, Mr. Vice President, you know, I heard Senator Lutchmedial speak about San Fernando Court and the state of disrepair that San Fernando Court is in. And believe it or not, Mr. Vice President, moving from this general, this specific to the general, can be seen to have benefits if we take that example that Senator Lutchmedial placed on the record as it relates to the San Fernando Court, and I'll explain what I mean by that. The refurbishment works, Mr. Vice President, undertaken by the San Fernando Supreme Court, as a matter of fact, had to be closed to ensure and the court had to be closed to ensure the completion of the work. Based on the law as it exists in Section 74, it means that if a new court, that's the old Section 74, because we are dealing with the specific, it means that if a new high court has to be built, it has to be built in San Fernando. And the judiciary is now locked in legislatively from moving its operations anywhere outside of San Fernando. So that very same example that Senator spoke about, the disrepair of the court, had the judiciary have this legislative power back then, you may very well find that if San Fernando, there simply was not a right fit or right place for this building, for a new court to be built, the judiciary could have explored other options that are available. Another example, Mr. Vice President, I know is with the Children's Court, for example, in South, which is by law a high court, was cited outside the boundaries of San Fernando after all efforts to find a site in San Fernando itself. So when there was a desire to now create the Children's Court, so that children's matter, and you see it comes back again against another statement made by the Honorable Attorney General, taking the court to the people. Even in that instance, that example of the Children's Court, even in the attempt of the judiciary to take the court to the people, the old Section 74 would have no doubt presented challenges for the judiciary, because it means now if I have to look for a building, if I have to look for a space, if I have to look for a place, it has to be in San Fernando, because that is what the law is requiring of me. And that is just simple, by virtue of these two simple examples that the judiciary has already faced. I just wanted to place those practical examples on the record to explain how critical, as simple as this, moving from the specific to the general is. It's really not that simple. It really assists and really will assist the judiciary in its operations. And once we give the judiciary that support, each of us as legislators would have done our part in assisting in the administration of justice and assisting the judiciary in, of course, achieving, Mr. Vice President, its mandate. And that's on clause 3, Mr. Vice President. Mr. Vice President, now I wish to move to clause 4 of the bill. And as I said, I will not look at the entire clause 4. What I would focus on very briefly in my presentation, Mr. Vice President, will be in that clause 4, the new subsection 2 and 3 that it introduces, the new subsection 3. Now, 2 and 3, for the benefit of my colleagues who are following the bill, the new subsection 2 and 3, that is the clause, those are the new subsections which allows the Chief Justice to appoint place and times for trials. And yes, I would have touched on that, so I wouldn't belabor that point at all. I would focus on the new subsection 13, That new subsection, Mr. Vice President, makes provision in the case of the commission of virtual offences, and hopefully they'll be able to address some of the concerns Mr. Teemal would have raised. I would look at, Mr. Vice President, the new subsection 14 and 15. Those new subsections deals with, it allows, well, in my own words, for adaptability and flexibility in the administration of justice. I will look at that. I would look at the new subsection, like I'm looking at everything. I would look at the new subsection 16 and 17. And that, Mr. Vice President, provides a way by which an accused can apply for a transfer of his matters. And I want to look at that because, of course, it deals with the interest of justice point, particularly the interest of justice point. And, of course, if time permits, briefly look at section 18 and 19. I really think I'm looking at the entire section. Anyway, Mr. Vice President, as I continue, so I'll start, of course, by looking at the new subsection 2 and 3. And I will not belabor that point because, of course, I would have already spoken in looking at clause 3 of the bill, what we were hoping to achieve, moving from the very general to the specific, from the specific to the very general, and by way of examples of the issue that arose with the San Fernando court, and of course the issue with the children's court that was intended to be placed in, that is in San Fernando, I would have tried to, of course, in my own way explain why, by those examples, why that movement was critical, and that amendment that we brought to section 74 was critical. So I'll move along, Mr. Vice President, to section 7, the new subsection 13. Now, the new subsection 13 deals with the provision of virtual offences. Now, Mr. Vice President, this new subsection recognizes, and of course, virtual, before I even get into that, let's just think about the times in which we live in. It's a new age, new technology, and no doubt new crimes and new smartmanism existing throughout the world. Of course, Trinidad and Tobago is not left behind. Mr. Vice President, the new subsection recognizes, and of course, this new subsection 13, it recognizes, Mr. Vice President, and appreciates that there are crimes that will be committed virtually. In circumstances, Mr. President, but this specific provision, Mr. Vice President, deals with, this entire section deals with, this section deals with locality. Am I going to have a matter being heard in North? Am I going to have a matter being heard in South? Am I going to have a matter being heard in Tobago? And we know one of the major considerations of where these matters are being heard is based on the locality of the crime, where the offense is being committed. There are virtual offenses that occur on a laptop, that occur on a computer, that the locality of the offense is on a phone. The locality of the offense is very difficult to ascertain, very, very difficult to determine. And we have all spoken about the interest of justice as a consideration in determining where matters are heard. But how can we uphold the interest of justice in virtual offenses if we have no clue where this offense is being committed? What can a judicial officer justifiably use to say, well, I am docketing this matter in Sando, or I'm docketing this matter in Tobago, or Port of Spain, and you really cannot ascertain where the offense itself was committed? And as a consequence of that, in recognition of the commission of those virtual offenses, Mr. Vice President, where the locality of the offense is very difficult to determine, to my mind, that is why we have this new subsection 13 that introduces the provision for virtual offenses. As an example, Mr. President, the origin of cybercrime offenses, for example, which involves the use, as I said before, of a computer as an instrument to further, let's say, illegal ends such as fraud, certain elements of trafficking in persons, Mr. Vice President, child pornography, Mr. Vice President, and crimes associated, don't talk about intellectual property, crimes that are all committed through the use of a device. And you cannot determine the locality of those offenses. This provision, by saying in circumstances where an offense occurred, because this is what the new subsection 13 says, in circumstances where an offense occurred virtually, a specific physical location cannot be established for an offense, or it is otherwise in the interest of justice, the Director of Public Prosecution may exercise a discretion to file an indictment at a designated registry of the Supreme Court for the Criminal Court Division in North Trinidad, South Trinidad, and in exercising the discretion, the discretion, the Director of Public Prosecution shall have regard, and of course it goes on to talk about all of the considerations that will be operating in the Director's mind in making this particular decision. Mr. Vice President, in such circumstances, what this new subsection does, as it clearly states in the legislation, in the bill, is that, of course, it gives the DPP the discretion to file indictments at any designated registry of the criminal court, North, South, and in Tobago, of course, having considered all of the evidence that is available to the DPP, and apart from just evidence, live issues such as the availability, Mr. President, sometimes of witnesses. And of course, paramount is the interest of justice. So when we speak of virtual offenses and the inclusion of virtual offenses, Mr. Vice President, in this new subsection, it is with the intention, it's with the understanding, that there are offenses based on the way in which things are progressing, because crimes are progressing and developing, that there will be virtual offenses in which the locality is difficult to determine. Where do I docket this matter? If I docket this matter in South, I can be challenged because, of course, a defense counsel, a bright defense counsel like myself back in my days, could challenge the DPP, could challenge the prosecution as it relates to what was the consideration. We have an offense committed on a cell phone, and there are many evidential objections, Mr. Vice President, in matters like that can be raised as it relates to virtual offenses. And as a consequence of that, Mr. Vice President, I wanted to, of course, lend my support to this inclusion in the bill, because certainly the DPP operating in the Honorable DPP's mind will, of course, be the interest of justice. And I strongly believe we don't need to legislate to the Honorable Director or the judiciary. What we have included the interests of justice. But I have every confidence in our independent arms of state. And I believe that they all understand what the interests of justice means. And that, of course, based on the evidence that is before these honorable offices, based on, of course, witnesses, and more so, upholding the rule of law, that in instances where virtual offenses are created, the right decision will be made as to where these offenses ought to be docketed, where it ought to be heard. And I just want to say that I lend my support wholeheartedly, Mr. Vice President, to those virtual offenses, and I believe it was very critical for us to make that inclusion in this particular bill. Mr. Vice President, if I move on now to the new subsection 14 and the new subsection 15, and it's what I term the adaptability and the flexibility new subsections. Now, these new subsections, Mr. Vice President, it grants the court discretionary powers to order that a trial take place, of course, in North Trinidad, having considered certain specific factors, and once it furthers the interests of justice. There is a widely held view, Mr. Vice President, that court systems, for example, operates in a very, how should I put it, a very black and white environment, and it's inflexible to surrounding changes. There have always been that statement. Some even say, Mr. Vice President, that court systems seem to be out of touch with day-to-day realities. And of course, I would have made many of those criticisms myself when I was a practitioner, you know, because you understand the real challenges, the on-the-ground challenges of the accused, of your witnesses, of your clients on the ground. So therefore, there is this statement that courts sometimes are out of touch with the realities. I believe this new inclusion, the inclusion of this new subsection, that's why I term it as the flexibility and the adaptability new subsection. Mr. President, it is clear to my mind from the suggested amendments that is recommended in this new subsection that changes, that what it does, is that it changes the legal framework to the extent of what is required, Mr. Vice President, to support the judiciary, of course, in directly responding to the changing needs of the society. Mr. President, Vice President, while I believe appreciating the current shortfalls of the existing legislation. So again, that's why I refer to this new subsection as the adaptability and the flexibility clause. Mr. President, this suggested amendment itself, it lends itself to the real possibility, Mr. Vice President, that a matter may have to be moved from North Trinidad for a case management purposes. It also allows for the security of witnesses. Mr. Vice President, it of course has its savings. You know, you can save time, you can save resources, because this new subsection, especially for the members of the listening public, this new subsection 14 and 15 says, well, especially 14, but let me not read it because I'm sure I will run out of time. But this new subsection itself, in essence, it's where a judge or judicial officer may in any case, either before the trial or on the arraignment of the person, order that the trial of such a person shall take place in North Trinidad if satisfied that, of course, a fair trial, if it's convenient to the party, and of course in the interest of justice, take place. And I believe that this adaptability, this flexibility is very critical because, you know, I mean, I know Senator Teemal asked the question about if the North has something different that the South doesn't have. But if you look at clause 15, the new subsection 15, it says, notwithstanding the place where complaint or indictment is filed under this section, the court shall give directions as to the place and time for the trial. And if the court directs that the case is to be tried at a place other than where the complaint or indictment was filed, all witnesses and the accused persons who are bound to or summoned to attend the trial shall be summoned to attend it. So I believe, notwithstanding 14 above, 15, you still have that flexibility where, even though, yes, the court can say, okay, let's bring a matter to the North, the 15 still allows the court, in the interest of justice, to not simply make a decision because North is better than South, certainly not. It gives the judicial officer the ultimate flexibility and discretion, considering all the facts of the case, to decide where this matter is going to be docketed. Mr. Vice President, how much time do I have?
You finish at 5:10. You have 7 minutes.
Okay, thank you, Mr. Vice President. Mr. Vice President, now, in this particular clause, Mr. Vice President, this particular new subsection, of course, and throughout the length and breadth of this bill, what we see featuring is the interest of justice. And I do agree that the interest of justice is, of course, critical to the administration of justice. And I'm sure the Attorney General, as it relates to the concerns that Senator Teemal would have raised and Senator Lutchmedial, I'm sure the Attorney General in his winding up will address that concern and, of course, the drafting behind, the drafting concerns that would have been raised by the honourable senators. Mr. Vice President, if I now briefly, in the 7 minutes that I have, if I now look at the new subsections 16 and 17. Now, this new subsection is where the accused can make an application of an accused to transfer his matter. So a matter has been docketed in North or South or Tobago, or wherever the case may be. This provision allows, again, a kind of due process provision where, and that's just in my own words, where notwithstanding the fact that a decision has been made by the judicial officer as to where the matter ought to be heard, you still have the accused having that right to make an application for his matter to be transferred. Now, these subsections, Mr. Vice President, it affords discretionary power, of course, to the court and provide by way of application for the DPP or the accused to have matters transferred, Mr. Vice President. It is, of course, Mr. President, significant that a court can determine that a matter must be transferred if the ends of justice so requires. And that is very, very important. So notwithstanding a matter being docketed in North, South, or Tobago, there may be issues that may arise during the course or in consideration before the starting of these trials that may warrant, especially as it relates to the interest of justice factor, that may require matters to be transferred. And of course, by giving the accused an opportunity to make an application, and even in this instance, the DPP, for these matters to be transferred, I believe that is critical because, again, you're not pigeonholing or in the interest of just, at least what I should say is that we ensure that the interest of justice, again, is upheld by giving the accused, of course, that opportunity to have a say in where his matter, of course, is docketed to be heard. Now, of course, applications can be frivolous application where I don't want to get up 6 o'clock in the morning to face traffic to come down to Port of Spain when the offense is committed in Port of Spain. And there are all kinds of frivolous, sometimes, excuses that are made in certain applications. But that is why it's a discretionary power. Because in the exercise of its discretion, the court, again, will consider numerous factors, the interest of justice, of course, being paramount. And before a decision is made as to whether or not I will grant the application to the accused, as it relates to where his or her matter, of course, is being heard. Now, Mr. Vice President, it is, of course, significant to a court that a court can determine that a matter must be transferred. As I said before, if the ends of justice so requires, it is also equally significant that the DPP has the ability to apply for the transfer of a matter. And I believe giving the DPP the opportunity to do that, again, can assist him. Let's say, for example, you have real live human beings who work in the office of the DPP. You may have lawyers who, for whatever reason, significant reasons, that whether it's security, whether it's safety, may go to the director and say, well, boss, I need this matter to be heard elsewhere because of X, Y, and Z. And by giving the DPP that opportunity that he too can make the application for these matters to be transferred, again, I believe it really allows for the director not to be locked down by where matters are docketed by the court, another layer of due process. Where, of course, you don't have matters now just being stuck there because a lawyer say, well, I asked the boss for my matter to be moved and it can't be moved, so I just don't show up to court. And those are real life issues that once you're on the ground, in the court, you understand that may arise. And by giving the DPP that opportunity, Mr. Vice President, for even these matters to be transferred, that is what this new subsection 16 and 17, Mr. Vice President, of course, intends to achieve. So, Mr. Vice President, of course, the new subsection 18 and 19 deals with the whole provision of in-person and the whole hybrid hearings. And I think we all understand how very important those virtual hearings now are, and of course the hybrid processes are. And if there was one good that came out of COVID, I'm sure we all will agree, was the extent to which we now use technology. And we need to commend, of course, I need to find a way to commend my government. The PNM government, of course, running with the lessons that we learned from, of course, the pandemic. We have the Ministry of Digital Transformation, which is like pot salt, and is going to help us to be able to achieve all that we need to achieve to move the criminal justice system, to move the administration of justice system into the new frontier, into a new generation, a new time. So, Mr. Vice President, I will briefly end. I will end as I started. All hands on deck, a coalition of the willing is what we are called upon. The judiciary has done its part. We as legislators are now called upon to do our part, and we as the government ask for the support of this bill. I thank you, Mr. Vice President.
Senator Vieira, SC.
Thank you, Mr. Vice President. Let me begin by saying that I have circulated a proposed amendment, and let me give credit to the person that inspired the amendment. That was Senator Lutchmedial, having heard what she had said about Clause 4B16. So I want to give credit where it's due. The inspiration for the amendment came from her. Now, this simple but important bill seeks to amend two statutes: the Supreme Court of Judicature Act and the Criminal Procedure Act. The amendments pertain to court sittings and related matters. They seek to upgrade and to streamline administrative and procedural processes for resolution of criminal cases in the High Court. At Clause 3, the bill seeks to broaden the court location references, which currently obtain under Section 74. So instead of sittings of the High Court in Port of Spain, San Fernando, and Scarborough, the reference will now be to court sittings in North Trinidad, South Trinidad, and Tobago. And there are two benefits to this change in nomenclature. First, it means that court sittings will no longer be statutorily restricted to our capital cities. And so this is going to promote decentralization and accessibility for the public and other stakeholders. Secondly, it harmonizes the language between the Supreme Court of Judicature Act and the Criminal Procedure Act. At Clause 4, the bill amends definitions at Section 2 of the Criminal Procedure Act and regularizes a number of matters. So it starts off with an attempt to simplify and clarify the titles and roles related to the registrar, deputy registrar, and assistant registrar. So when you look at the Criminal Procedure Act, the definition at Section 2 is convoluted. But Senator Teemal sought clarification, and I tend to agree with him. I don't know if the proposed definition is making things any clearer. Because if you read the proposed definition, we are in effect saying that the registrar is a deputy registrar and assistant registrar, and that just doesn't make sense to me. What is also clear, though, is that what has been going on in practice now has statutory force. So we're talking about court hearings to be in person, to be virtual, or hybrid. Now, Senator Dillon-Remy had a concern about what happens with these virtual hearings. And she's right. I mean, we do have glitches in a system where you have people being bumped off for the internet connection being poor. But I want to tell you, Senator, that in my experience, the judges have become very adept at handling the technologies. And what tends to happen in practice is that you'll have virtual hearings for case management conferences. But when time comes for the trial, and you want to do your examination in chief and cross-examination, those tend to be in person. So we have the hybrid model being used more in practice. No longer will we be using the 19th century language, which treats with place, time, and mode of trial in relation to wards and counties. Instead, we will now speak about North Trinidad, South Trinidad, and Tobago, and the legislation says what those designations consist of. The designation court as a place for trial is also made clear, and provision is made for the Chief Justice, by order, to appoint places and times for trials in North Trinidad, South Trinidad, and Tobago. The legislation empowers judges, when it is necessary in the interest of justice to do so, and subject, of course, to directions issued by the Chief Justice, to hold court sittings anywhere in Trinidad and Tobago. So that's a remarkable accomplishment there. The bill confirms the Chief Justice's power via practice direction to direct how proceedings, documents, and other media will be filed at the registries. And finally, the bill gives the DPP discretion to file indictments at any registry where an offense occurred virtually and a physical location cannot be ascertained or justified for an offense. Now, Senator Teemal picked up on the virtual, and he wondered, well, what kind of offenses are we talking about? Where will I find it? And so, of course, as we have heard, virtual crimes are really known as cyber crimes, and they encompass a range of illegal activities carried on in the digital realm. So, for example, phishing, where you're sending fraudulent communications, identity theft, ransomware, which we heard so much about in the recent TSTT incident, hacking, cyberbullying, data breaches. All of these are data offenses, and they will be found whether under the Data Protection Act or in the cyber crimes legislation that we are still to bring to Parliament and conclude. So those are just a few examples. There are many other forms, of course, of virtual crimes that can harm individuals, businesses, and society as a whole. But the point here is that we are now allowing for these crimes to be dealt with statutorily in this form. So the proposed amendments are uncontroversial. They clarify certain matters, and they will enable our courts and registries to be both modern and flexible. These administrative and procedural changes will help streamline our court processes, and I think they will go some way towards reducing backlog and delay. They should lead to faster resolutions and a more efficient judicial process. Modern, flexible administrative judicial systems are in fact needed to cater for the situations that we've been talking about, like virtual offenses. These administrative and procedural changes should make it easier for the public, lawyers, and other stakeholders to access court service, to be able to attend court sittings held outside of our cities where the interests of justice so require. They will facilitate electronic filings and online access. These administrative and procedural changes may, in due course, enhance public confidence in the legal system, especially towards ensuring that justice is perceived not just as fair and timely, but relevant and accessible. A lot of talk has been made about interests of justice. I would just point out that the term interest of justice is a term of art that is regularly used in litigation, but it's also dealt with under the criminal procedure rules, under the mantle of the overriding objective and dealing with cases justly. So there's a whole philosophy and stuff behind the little term interest of justice, but when you see it there, you know what it means. So I believe that these amendments can foster greater, and I like the word that the AG has used at least twice in his contributions, interoperability between registries, attorneys, the DPP, the public, and other stakeholders. And they should, I believe, facilitate smoother and better coordination among the different branches of our justice system. And with those few words, I thank you.
Senator Maharaj.
Thank you. This bill, like the previous one, is a very important but gradual, I should say, modernization of the administration of justice. And so for that, I welcome it, and I'm sorry that the Attorney General missed the note of optimism when I expressed my hope of more. But I do have a genuinely rhetorical question to ask this time, and that is, were it not for COVID, when do you think we would have had virtual hearings or virtual case management or any of those things? And I ask that question because I want to underscore the value of bold action, because I think that is what the administration of justice needs, and we have to have the courage for it. In this case, and I think Senator Vieira used the word decentralization. I frankly don't see why it's necessary to redefine Port of Spain and San Fernando into North and South Trinidad. It is wherever the Chief Justice, and where it is required for him to consult, declares a place suitable. But I know the gradualized approach to this, because that is what we should be imagining, a system and a structure and infrastructure of decentralized justice, a justice system that is decentralized, that serves everybody at the lowest possible cost, at the highest possible quality. Do we really need to be spending $85 million every year in transporting prisoners when we have so much state land up in the east that we could put a high court and move prisoners in a short space? How are we spending our limited funds? Why are we burning all this carbon into the atmosphere? Why are we pushing everything into the city? We have an important hall of justice. It's a complex, it's beautiful, but we need many small courts that fulfill the function. The time will come when we can't get into Port of Spain for floods. How many times would you put off cases? And so the embrace, the challenge for us is not just to disconnect the law from the hidebound past, but to imagine a world that we are very quickly going to be living in. And so I support everything here in this bill, but I want to put into our heads the possibility that we may be able to deliver justice more speedily at a lower cost if we can conceptualize a justice system that is not structured on large construction buildings, but fit for purpose using technology. And with that, I thank you.
General.
Thank you very much, Mr. President. I'd like to deal with one of the submissions of Senator Lutchmedial, which was not her first, but one that I think requires a little bit of attention. She referred to the language in section, well, it's clause, in the clause of the bill, which we seek to amend the Act with, clause to repeal section 3 and substitute the following section. That begins at page 4 of the bill, and then that takes us right across to page 10. And the point that she made with reference to that section that is being replaced by this bill is she would prefer to have consistency in the language that is used, because in some sections the words "in the interest of justice" are used, and in clause 313, no, not clause 313, in clause 316, there is used the words "the ends of justice so require." So she has expressed concern with the fact that there should be consistency and that the words "interests of justice" should be used throughout. And my answer to that is the words "interest of justice" and "ends of justice" can be used interchangeably. They don't mean anything different. But more to the point, we have the new criminal procedure rules. And I had introduced that when I was speaking on the earlier bill, the AJIPA bill, amendment bill. But I'd like to read into the record Part 3, Clause or Rule 3 of the Criminal Procedure Rules 2023, which have been introduced in late 2023 to implement and work alongside all of the legislation dealing with the criminal justice system and guides the discretion of all judges in the criminal jurisdiction. So Part 3 of the Criminal Justice Rules 2023 is headed the overriding objective. And Part 3, Rule 3.1 says the overriding objection is to deal with criminal matters justly. So let's bear in mind the interests of justice, the ends of justice, which are used in the clauses in this bill, where the ends of justice so require. Rule 3.1, the overriding objective is to deal with matters justly. Rule 3.2, it is the duty of the court and all parties and all participants at every stage of proceedings where the context so requires to further the overriding objection. And then Rule 3.3, so this is a direction to all judges when they are dealing with matters which come before them. Dealing with a criminal matter justly includes A, dealing with the prosecution and the defense fairly. B, ensuring the protection of all of the rights of an accused person. C, considering the interests of the accused, witnesses, victims, and jurors, and keeping them informed of the progress of the matter as necessary. D, dealing with the matter efficiently and expeditiously. E, ensuring that appropriate information is available to the court, particularly when bail or sentence is under consideration. And F, dealing with the matter in ways that take into account Roman 1, the gravity of the offense, 2, the complexity of what is an issue, 3, the consequences for an accused and others who may be affected, 4, the needs of other matters, and 5, allotting to the matter an appropriate share of the court's resources while taking into account the need to allot resources to other matters. And then Rule 3.4 says, the court must seek to give effect to the overriding objective when it A, exercises any discretion given to it by these rules, or B, interprets the meaning of any rule or practice direction. So it is my respectful submission to this House and to the members, and in answer to Senator Lutchmedial's concern at the inconsistency between the terms interests of justice and ends of justice, that whenever the judge comes to exercise a discretion as prescribed by the amendments that we are seeking to pass here, that judge is mandated by the criminal procedure rules to apply the overriding objective And that overriding objective requires that judge to have regard to all of the matters that I've just set out. So that I do not think that the inconsistency in language, and I don't accept that, but it is the language that was used by Senator Lutchmedial, the difference between ends of justice and interests of justice make a difference when the judge is sitting to adjudicate on the matter, because the rules prescribe the matters which the judge takes into consideration and gives that judge an overriding discretion to ensure that the trial is dealt with fairly in the final analysis, in the interest of justice, to meet the ends of justice. So that's my answer to that first point of Senator Lutchmedial. Senator Lutchmedial made a couple other points, which I will just touch on briefly. And one of the further points that was made is on the question of the definition of hybrid trial. This requires the courtroom to be sufficiently equipped to facilitate hybrid trials, and the government needs to ensure that resources are allocated for same. And in that general context, the concern was expressed about the witnesses and other persons having access to the facilities that the court is providing for purposes of dealing with hybrid trials. Well, one of the things that I answer in relation to that, in response to that, is that the judiciary has committed itself and expended a considerable amount of resources and money in equipping the virtual access centers around the country. There are currently 22 virtual access centers, 5 of which are in Tobago. That is under practice direction, May 17, 2021. Those virtual access centers have been equipped with customer service representatives, and this is in answer to one of the concerns that Senator Dillon-Remy had raised as well, that litigants who do not have the required technology should be presented with clear guidance for the hybrid virtual access process, and the need to ensure that persons have access that is necessary. I accept that concern, but in answer to both Senator Lutchmedial and Senator Dillon-Remy, the virtual access centers, not only are there the 22 across Trinidad and Tobago and the 5 in Tobago, but those virtual access centers are equipped with customer service representatives to ensure that self-represented litigants and witnesses who are using those centers have sufficient support and guidance when participating in virtual hybrid matters. So there is a considerable effort that has gone towards recognizing that people are differently abled. When I remember many years ago when my daughters were very young and I was having difficulty getting access to my computer for something. My 8-year-old daughter at the time said, "Dad, give it to me." And she passed me back the computer in 2 minutes and said, "There, I've got it for you." The point is, people are differently abled, but the judiciary recognizes that they will give the support and dedicate the resources and the specialized service towards supporting persons who are differently able. And I don't mean that in a disabled sense, but some of us don't use the technology as well as other people do, and the judiciary recognizes that. So I see no hesitancy in recommending the hybrid and the virtual systems that are now part of our reality, which we are every day, and Senator Hassel Bacchus, who is our resident expert on these matters, has given us the assurance that it's not a panacea, it is not a silver bullet. There is constant daily commitment to improving the quality of the new world in which we live, in which so much is digital, so much is hybrid, so much is virtual, and the more we use it, it's like riding a bicycle. The first day you get onto a bicycle, you fall off, and you ride it a couple more times, and then you're riding without even holding onto the handlebars. You get better and better at it the more you use it, and that is what the virtual system is encouraging among the population of this country. We give it to you, we have people to help you, and the more you use it, the more familiar you become with it. So those are my couple answers to two of the principal concerns that were raised as between Senator Lutchmedial and Senator Dillon-Remy. I accept the concern that Senator Dillon-Remy also makes, that there needs to be sensitization and public education in terms of assisting the public in the rollout, and that is part of what I've already spoken to in terms of the commitment of the judiciary, which we are very, very much aware of. I had the unique experience, Mr. President, last year. I was encouraged to join the Chief Justice and the Court Executive Administrator on an IDB-funded trip to Spain to deal with digital courts. And I was present in Spain over a course of a week in training programs and visiting with Ecuador and 4 other countries out of South and Central America and Spain. And when we came out of that consultation, everybody in that consultation was overawed by the fact that the Trinidad and Tobago judiciary is ahead of many countries in the Western Hemisphere in its digital capacity and its technology that it has driven in making courts that much more accessible through the digital revolution that Chief Justice Ivor Archie has introduced to Trinidad and Tobago. And I commend him for that, and I encourage him to keep up the good work. Senator Teemal expressed some concerns. He was concerned about the removal of the registrar, and I say to Senator Teemal, under the legislation that has been brought into effect, Section 768 of the Supreme Court of Judicature Act, there is only one registrar of the Supreme Court, and all of the others are deputy registrars and assistant registrars who function substantively when they're in charge of their particular unit with all the powers of a registrar. It's a process of streamlining. There is also the other concerns that Senator Teemal has urged us, whether they using the term in virtual mode rather than virtually. Well, that's with respect, I accept. That may be for the drafter to consider. I don't claim to be a draftsperson, and as I said in the earlier debate on the earlier legislation, and in this regard, I would christen Senator Teemal as one of our stakeholders with whom we consult. As the suggestions come, and we have to come back here to improve it, we will improve it. We will take that into consideration with the Law Reform Commission. As it stands now, I think that the bill that we have before the House is good enough to be passed in the language that we presented with, and I ask members to support. And with those few words, Mr. President, I beg to move. Thank you.
Honourable Senators, the question is that a bill entitled An Act to Amend the Supreme Court of Judicial Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Thank you very much, Mr. President. In accordance with Standing Order 66-1.
One moment. Look.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters.
Attorney General.
Thank you, Mr. President. In accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provisions Administration of Justice Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Miscellaneous Provisions Administration of Justice Bill 2023 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Okay. Honourable Senators, there are 4 clauses in this bill. We have circulated amendments by Senator Vieira. I'm assuming that everyone is in possession of these amendments, these proposed amendments. Yes? Okay. All right, so we shall begin. Clerk.
Clauses 1 to 3.
Honourable Senators, the question is that clauses 1 to 3 stand part of the bill. Honourable Senators, the question is that clauses 1 to 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stands part of the bill.
Clause 4.
Honourable Senators, the question is that clause 4 stand part of the bill. Senator Vieira.
Chair, before we get to my amendment, I would like to raise the issue about registrar, the deputy registrar, because what we are saying is a deputy registrar and assistant registrars mean the registrar, deputy registrar, and assistant registrars appointed as such under the Supreme Court of Judicature. And to me, that doesn't sound right. To me, what you want to say is registrar, the office registrar, includes deputy registrar and assistant registrar. But I just find that the language here is clumsy, and I don't know if we could improve on it.
Attorney General.
Thank you, Mr. President. Chairman, I always defer to Senator Vieira, but I regret that on this occasion, I think the language is sufficiently clear.
Okay. Senator Vieira, your proposed amendment?
Thank you. So with regard to my proposed amendment, let me say, as I said earlier, that I thought that Senator Lutchmedial's observation on this clause were very helpful. Now, my proposed amendment doesn't make any fundamental change to the clause. I've simply recalibrated the order. I've abbreviated words that I saw as redundant, and I went with the well-known phrase, in the interest of justice, rather than reaching for the ends of justice, because, as Senator Lutchmedial pointed out, the phrase has the advantage of being consistent. So that's it.
Attorney General.
Thank you, Chairman. I won't repeat myself other than to say, I don't accept the proposed amendment, and I won't repeat myself other than to say that I spent some time in my wind-up referring to the criminal procedure rules, clauses 3.1, clauses 3.2, and in particular, clause 3.3. And when one has regard to the language of clause 3.3, it spells out very clearly what is meant and what are the considerations that any judge must take into consideration. So I think the language as used in the bill, clause 30, subclause 16, which Senator Vieira wishes to amend, is sufficiently clear. It is assisted in its interpretation by the rules, the criminal procedure rules, and I don't accept the proposed amendment.
Okay, Senator Vieira, is your intention to have the question put on this amendment, or would you withdraw?
Chair, my role here is to help. I am not pushing any particular wording. I understand the difficulty that the government faces. Were my amendments to be accepted, because you'd have to go back downstairs, would have to go back to the other place. I get it. I could live with it how it's cast, but I just think we could have done better. But I understand the logistical problem. So I leave it at that. I will withdraw my amendment.
Okay. Okay.
And I say thank you to Senator Vieira.
Sure. All right. Honourable Senators, the question is that clause 4 now stand part of the bill. Those in favour, Senator Teemal.
Yeah, that's one point I'd like to raise. I did mention that in the Parent Act, Section 3.7, in dealing with transfers, that there were time periods that were legislated there for the application of the transfer and then for the registrar to serve warrant. I can't remember exactly the period, but I think it's 10 days and 7 days respectively. I could be wrong. But in the amendment before us, we do not have any provisions regarding time. and I was just wondering, whether or not we should have included something with regards to time.
Attorney General.
I appreciate the point, Senator, but I'm satisfied with the language of the bill and the application of the Parent Act. Thank you.
Senator Lutchmedial, you had your hand up, no? Okay. Honourable Senators, the question is that Clause 4 now stand part of the bill. Those in favour say aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate.
Thank you very much, Mr. President. I wish to report that the Miscellaneous Provisions Administration of Justice Bill 2023 was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Miscellaneous Provisions Administration of Justice Bill 2023. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters.
Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 4, Number 1, and the Criminal Procedure Act, Chapter 12, Number 2, in relation to the place and time for sittings of a court and to provide for related matters be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Supreme Court of Judicature Act, Chapter 401, and the Criminal Procedure Act, Chapter 1202, in relation to the place and time for sittings of a court and to provide for related matters.
Acting Leader of Government Business.
Mr. President, I beg to move that the Senate do now adjourn on a date to be fixed.
Honourable Senators, before I put the question on the adjournment, leave has been granted for a matter to be raised on the motion for the adjournment of the Senate. Senator Vieira.
Thank you, Mr. President. In 2015, while working as the consultant for the World Intellectual Property Organization on making amendments to the Copyright Act to bring us within the Beijing and Marrakesh treaties, I met with stakeholders. And during those consultations, the desirability for an expansion of the term of copyright protection for our authors, the producers of sound recordings, and the moral rights of authors and performers became manifest. In fact, there was unanimous support for that goal. However, as the WIPO brief was restricted to provisions relating solely to Beijing and Marrakesh, I was unable to include amendments relating to the expansion of the term for copyright protection in the bill, which eventually came to Parliament, notwithstanding the positives. So happily, after the very encouraging stakeholder consultations, the Intellectual Property Office at the Ministry of Legal Affairs, led by the Controller, Mr. Regan Ascarali, took up the baton, among other things, reaching out to WIPO for their views on the proposal. Again, the feedback was very positive. So accordingly, based on stakeholder and WIPO support, the IPO, the Intellectual Property Office, crafted a policy document and prepared a note for submission to Cabinet in the hope that amending legislation would be brought to Parliament. Today, nearly a decade since those initial stakeholder consultations, nothing has been brought to Parliament. So I call on the government to make the following amendments to the Copyright Act. At section 19(1), by deleting the word 50 and substituting it with the word 70, so it would read as follows. Subject to the provisions of subsections 2 to 5, copyright and moral rights of the author shall be protected during the life of the author and for 70 years after his death. At section 19(2), by deleting the word 50 and substituting it with the word 70, so it would read, in the case of a work of joint authorship, copyright and moral rights shall be protected during the life of the last surviving author and for 70 years after his death. At section 19A, by deleting the word 50 and substituting it with the word 70, so it would read, the rights protected under section 18(4) shall be protected until the end of the 70th year following the year in which the performance was fixed in a sound recording, or in the absence of such a fixation, from the end of the year in which the performance took place. At section 21(4), by deleting the word 50th and substituting it with the word 70th, so it would read, the rights under this section shall be protected from the moment in which the performance takes place until the end of the 70th year in which the performance was fixed. At section 22(2), by deleting the word 50th and substituting it with the word 70th, so it would read, the rights under subsection 1 shall be protected from the publication of the sound recording until the end of the 70th calendar year following the year of publication, or if the sound recording has not been published, from the fixation of the sound recording until the end of the 70th calendar year following the year of fixation. At section 23(4), by deleting the word 50th and substituting it with the word 70th, so it would read, the right to an equitable remuneration under this section shall subsist from the date of publication of the sound recording until the end of the 70th calendar year following the year of publication, or if the sound recording has not been published, from the date of fixation of the sound recording until the end of the 70th calendar year following the year of fixation. Mr. President, these are modest changes, but they will have substantial positive impact. They are modest changes in that we are only looking for an increase of 20 years from 50, as the law currently stands, to 70. In some countries, like for example Jamaica, the term of protection is the life of the author plus a century after his death. So the 70 years I am proposing is regarded generally as an acceptable international standard, and in fact, that standard already exists in at least 84 countries. So indeed, in some of our international markets, including the United States and Europe, the term of copyright protection for sound recordings extends not just to 70, but even 95 and 120 years. So we are lagging, and that puts us at an economic disadvantage. So to put the requested amendments in context, consider the following. The original recording of Gene and Dinah, composed in 1956, went into the public domain in 2006, 50 years after publication. The song Tempo, composed by Cecil Hume, performed by Maestro, and published in 1975, has just one more year before the sound recording falls into the public domain. And as Cecil Hume died in 1977, his family only have 4 more years to receive royalties. Winston Bailey, The Shadow, published Baseman in 1974. That sound recording fell into the public domain this year. And as Shadow died in 2018, his family are going to stop getting royalties for this and for all his other songs in 2068. Renorama, published by Lord Kitchener in 1973, that fell into the public domain in 2023. And as Kitch died in 2000, his estate will cease getting royalties from his very extensive repertoire in 2050. The purpose of copyright protection is to give creators the exclusive right to use and to distribute their work for a certain period. And this encourages creativity by allowing creators to benefit from their work, whether financially or through recognition. It also helps protect against unauthorized reproduction, unauthorized use of their works by others. And so the term of copyright protection
Senator, you have 2 more minutes.
is important because it determines the length of time during which a creator or his designated rights holder has exclusive right to his work. The time frame allows a creator to control how much of his work is used, reproduced, and distributed. It also affects when the work will enter into the public domain. So as we transition from this to this multi-dimensional economy, which should include the orange economy, these changes will benefit our creators, performers, and the wider economy. There's a lot I can say, and there are a lot more examples I would love to give. Time does not allow. Suffice to say that the proposed amendments are consistent with the philosophy and ideals of the copyright regime. They're in step with the rest of the world, and they can bring new life to old sound recordings. The proposed amendments will enable our local artists and producers to compete globally in the digital space, among other things by being able to digitize their old sound recordings and their old masters. By ensuring that a significant number of our local works will be copyright protected for 20 years longer, the country's ability to commercially benefit from its rich heritage and culture will be enhanced. I thank you.
Attorney General.
Very much, Mr. President. Mr. President, it is with a sense of pride and indeed a sense of almost elation that I'm able to say to Senator Vieira this evening, I have good news for you. I bring to the attention of the Senate this evening, but before that, let me preface it because I don't want it to appear to be a reaction. As a result of the very hard work by an inspired young man by the name of Regan Asgarali, the director of the Intellectual Property Office of the Attorney General, Cabinet yesterday passed a cabinet note to bring into effect everything that Senator Vieira has asked for. And that cabinet note was drafted by Mr. Regan Asgarali in consultation with me, following the consultations that have been held on March 2nd, April 13th, July 7th, August 19th, and October 22, that led to the amendment to the Copyright Amendment Act of 2020 and the policy document which had been formulated by the TTIPO to that end. And the cabinet note that has now been passed, which will find its way before this August Senate and the other place in the form of the legislation, is to extend the life of the author, and 50 years after his death, the life of the author, and 70 years after his death for authors and works of joint ownership and neighboring rights to be extended from 50 years to 70 years for performers and producers of sound recordings. It has also been recommended that the corresponding duration of the term of protection for moral rights be extended. And the note which came to Cabinet was informed by a policy document that had been prepared and given to me by Mr. Asgarali to inform the Cabinet. The copyright policy which had been drafted by the TTIPO justifying the extension of the duration of the term of protection for copyright and neighboring rights for authors, including works of joint authorship, performers and producers of sound recordings, extension of the duration of the term of protection for moral rights for authors, including works of joint authorship and performance with comments and approval from WIPO. All of that informed the passage of the note which was passed in Cabinet yesterday. In the international landscape, we took into consideration the very many jurisdictions, including the United Kingdom, the United States of America, the European Union, which have increased the term of protection of life of the author, from life of the author and 50 years after his death to the life of the author and 70 years after his death. And in this respect, the increased term of protection to the life of the author and 70 years after his death is consistent with the new global standard for the duration of copyright protection. The United Kingdom, the United States of America, and Europe are critical markets for copyright-protected works created by Trinidad and Tobago authors. And as such, the extension of the term of protection, which Cabinet has now approved, is in line with international best practice, whilst ensuring that our authors will benefit in the international markets. In fact, the International Federation of the Phonographic Industry, IFPI, has noted the growth and development of the creative industries in Trinidad and Tobago and recommended increasing the term of protection for sound recordings to 70 years in the Copyright Act. We took that into consideration. Mr. President, I would go further to say that we will now have a situation in which there will be an increase in the term of protection of sound recordings to enable Trinidad and Tobago's artists and producers to compete globally in the digital age. Yes. The retention of the current 50-year term of protection for sound recordings would have continued to subject holders to rights of unfair competition in a fast-evolving digital ecosystem, especially in light of the fact that the 70-year term of protection has become the new standard across the globe. Cabinet accepted those recommendations in its passage of that Cabinet note yesterday and joined at least 69 other countries in providing a term of protection of sound recordings up to the 70-year limit. As pertains to performers, part of the policy document informed us of a Billboard article which quoted the European Union Council of Ministers in Brussels, talking about performers who generally start their careers, and you have mentioned a couple of our own artists, Senator Vieira, start their careers young, and the current protection of 50 years often does not protect their performances for their entire lifetime. So that has been taken into consideration as well. So, Mr. President, in a nutshell, I am able to assure this House that as a result of the Cabinet note which was passed yesterday in answer to in elaboration of the hard work of Mr. Reginald Asgarali, which answers the concerns of Senator Vieira, the anticipated benefits of the Copyright Act, when amended along with the lines of this Cabinet note, will facilitate the extension of the duration of the term of protection for copyright and neighboring act rights for authors, including works of joint authorship, performers and producers of sound recording, facilitate the extension of the duration of the term of protection for moral rights for authors, including works of joint authorship and performers, to include the following: global competitiveness by Trinidad and Tobago's authors, artists, and producers, increased national, regional, and international investment, incentivizing creativity among authors, including works of joint authorship, performers, and producers of sound recordings, protection and stimulation of Trinidad and Tobago's heritage and culture, provision of remuneration for work, contribution to gross domestic product, and stimulation of the copyright industry, compliance with international trends in copyright duration, the development of our music industry, and harmonization with the trade policy of the Ministry of Trade and Industry for valuation and sensitization. Mr. President, in closing, I say again thank you to Mr. Regan Asgarali, and I beg to move.
Oh, yes.
Honourable Senators, the question is that this Senate do now adjourn to a date to be fixed. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to a date to be fixed.